Good morning, everyone. For those who can hear me, just waiting for some people to log on. There was a miscommunication for one of the scoring judges. Once we have everyone logged in, I'll go ahead and start with the introductory remarks, but I just want to make sure we have everyone logged in before we do that. Some of you are muted. If you want to be unmuted, let me know. You should be able to unmute yourselves. If not, I can go ahead and try to do that. Is there anyone who can't hear me? If you cannot hear me, I don't know if you would be able to respond since you can't hear me, but if there's something wrong with the audio, let me know. We can do it in the chat feature and we can try to figure that out. So I'm also checking text messages from the competition coordinator to make sure that everyone is good to go. One moment. All right, so Robin Feeney, are you having any problems? I just want to make sure that you're going to ask to unmute you.
I can't figure out how to change my name.
Okay. What role do you play?
I'm a juror, but now I lost everything. Everything was up but I couldn't figure out how to change my name to juror.
Okay.
Now I don't seem to have. Okay, wait, there you are. Okay, there's everything, but I don't know how to change my name to juror.
I wonder if that's something I can do. I probably can't do it on my end.
Like, I don't know where you go into it to change it.
So Robin,
yes.
Hover over your name, and then there'll be a blue, like where your picture is, there'll be a blue square.
I found it already.
Dots.
Thank you. I gotcha. Thank you. Oh my God. I'm sorry, you guys.
It's all right.
It's harder than you think it is.
We're all getting used to this technology across the country. It's okay. It's understandable.
Okay, I'm ready.
Okay. So
sorry.
Looks like I've got two jurors here. I think there should be a total of 4. You may be here just you're perfect. So your camera was, thank you. Excellent. Then the only one I think would be, let's see, I want to make sure we have, I've got Juror May, Juror Quinn, Juror Bertolino. I'm sure I mispronounced that. My apologies.
You said it correctly.
Okay. That's probably the last time I'll be able to say it.
One of the first times it's been pronounced that way. So good.
All right, so it looks like we got our advocates here. Excellent. If for some reason, this is a little off script, they gave us a whole script to say, but if for some reason you guys are having some technological issue, let us know, put in the group chat something. I really would hate for you guys to be in the middle of some type of examination or statement and something go wrong with a juror, they can't hear you, whatever it may be. Let us know, we'll put a pause to it and see if we can figure it out. All right, so my name is Jesse Salcedo. I'll be presiding over this round. Looks like we've received the message to get started. Oh, I guess we have it now. When I look to my left, it's because I'm looking to my phone and I have the group chat up for the entire group of the coaches and competition. And I'm thinking we're still waiting for an all clear is what I'm being told. So looks like we'll have to wait around for a few moments until we get that all clear. So bear with us, please. So it's taking a little bit longer than we anticipated. Looks like we're waiting on at least 3 other courtrooms to get ready. So my apologies to everyone. We're still waiting around.
Hi, I'm going to ask a question. Is the juror, somebody chatted, do we leave our video on or off, the jurors?
That's a great question. I'm going to pull it to the advocates if they rather have faces to look at rather than not. I think as an advocate, I like to see the people I'm talking to other than just a camera, but I'll leave it to the advocates. I guess we can do that now since the 4 of you are here. Those of you in favor of having the jurors feeds being up, go ahead and put a thumbs up. So no one, okay, everyone wants their cameras to be off then. All right, okay. So and I guess we'll go ahead and do that once we start up, or you can do it now. Either way is fine.
Okay, so I have another one, as long as we're sitting here. We're supposed to put in the prosecution team number and the defense team number on our scoring things. So they haven't told them to us yet.
Correct. I imagine they'll do that once we start the round. They'll go ahead.
Oh, okay.
Good question though.
Email that we all were sent. If you got your courtroom number, you should have the prosecution and defense number. It's on that. It's in that email.
Huh.
See the colored grid? They have all and all the names of the judges and everything. It's got the team numbers by it in the email.
Oh, found, okay. Cool, okay, I found it. Thank you.
So once we get started, looks like, and for some clarification, looks like there is an agreement that all jurors' cameras will be off. So once we get started, we can go ahead and turn those off. And if you can't do that, I can do it from my end. So once we finally get things rolling, I'll make sure to do that for everyone. I will say this too, since there was that confusion there, there's also a preference to have, and I'm sure the advocates have this, but for jurors to have it so that you only see speaking participants. Hopefully you receive instructions on how to do that. basically it's in setting, an option in the settings under video, and you would click hide all non-video participants. If that's too complicated, then is what it is, but that's what's being requested by the competition coordinator, so that you see only those who are speaking and who are going to be quote unquote on the record.
Hey, Judge, sorry for the interruption. Liz, I need to move you to a different courtroom. Can you hear me?
Yeah, I can.
I'm going to move you to courtroom 5. Do you mind just signing out of this Zoom meeting and then entering courtroom 5?
Yep, got it.
Thanks.
So as you can tell, still trying to wait and figure out things for jurors. All right, Juror Quinn, since it looks like we're about to start here, I'm going to go ahead and mute your video. Obviously, you'll still be able to see the participants. Again, if something comes up mid-round where anyone is having technological issues, please let us know. I would hate for someone not to be able to hear or see something. So hopefully we should be starting in a moment. All right, we've been given the go-ahead. Okay, so let's go ahead and start. Now, everyone looks like we got the message to start, so we're going to go ahead and start. Let's call the case of State of West Carolina v. Timothy Ray. As I said before, my name is Judge. You can say Jesse Salcedo. If you get my name wrong, that's fine. I don't care. Just say Judge. I'm fine with that. Scoring judges. Now, I've already told you this, to the two buttons on your lower left screen to turn off your audio and video. Look like that's done. But as I said, with the exception of if something happens where you can't hear something, please let us know. I really, really want to make sure the advocates have everyone's attention, please. All of the audio and video for jurors should remain off until the end of the round, and then we'll turn them back on so we can have comments and feedback. So the only ones on the video, which I can see, are going to be the advocates and myself. So without further ado, the attorneys, let's start with the prosecution, could make their appearances for the record, please.
Good morning, Your Honor. Gohar Tamizian, first name spelled Gohar, last name spelled Tahmician, here on behalf of the prosecution.
Thank you.
Good morning, Your Honor. Noel Areola, last name spelled Arreola, here on behalf of the prosecution. And when Your Honor is ready, we have 2 pretrial motions and some housekeeping matters to attend to.
Thank you. We'll wait to get to those until after we hear from defense. Defense, please.
Good morning, Your Honor. Name Braden Hodak, last name spelled Houdek.
Thank you.
Good afternoon, Your Honor. Miss Jessica Allen, Allen.
Hi there. All right. So prosecution, you mentioned that you had some housekeeping matters you wanted to address. If you could, please.
Yes, Your Honor. During the course of the trial, counsel may ask to approach for a sidebar. We ask that this be done constructively so the other judges could hear our arguments.
If you could just, that's fine. I'm assuming there's no opposition from defense. If you could just remind the court the first time you're doing it, and then from there, everything else is constructive, and I'll understand that to be it. Unless for some reason you want it otherwise, but I can't imagine why. But let's go ahead and do that constructively. That's good. Any other housekeeping matters?
Yes, Your Honor. Would you prefer that we formally tender the expert witnesses in this case?
Yes, please, so that the opposing counsel can have an opportunity, if they so desire, to voir dire the witness prior to the court going ahead and finding that that person is an expert.
Your Honor, the parties have stipulated on page 4, stipulation 1, exhibits have been pre-numbered and they shall retain those numbers regardless of the order they are introduced in trial.
Makes sense?
And lastly, we move that all witnesses be constructively sworn in.
That works. Is that all for your housekeeping matters on behalf of the prosecution?
Yes, Your Honor, just the pretrial motions.
All right. Before we get to those, are there any additional housekeeping matters on behalf of defense?
Yes, Your Honor. The defense has 1 pretrial motion in limine.
Beyond the pretrial motions eliminated, did you have any housekeeping matters you wanted to address?
It is our understanding that the federal rules of evidence and the federal rules of criminal procedure apply to this proceeding. Accordingly, we move to invoke Rule 615, the sequestration of all witnesses, barring the defendant, Mr. Ray.
Any opposition from the prosecution?
No, Your Honor. We just ask that the detective officer remain in the courtroom.
Any opposition on that from behalf of defense?
Yes, Your Honor.
All right, from my understanding, the rules were that officers would be sequestered. However, you do have the ability to contact and discuss any issues with your witnesses during the round. So let's leave it at that, so that if you need a moment to talk to your witnesses, let us know prior to their testimony, either because of motion to eliminate or something happened that you need to talk to them about. Let us know. We'll take a moment during a break in order for you to do that. But I don't want to be breaking every single time during the middle of this trial. Just during breaks, you can talk to your witnesses about that. Does that satisfy? All right, now prosecution, you mentioned that you had some motions to eliminate. Let's start with your first one.
Yes, Your Honor. The defendant, Timothy Ray, is on trial today for murdering his 6-year-old son after the boy spilled apple juice on the defendant's laptop. The defense filed a claim that they intend to raise an insanity defense, claiming that the defendant suffered from schizophrenia. It is the prosecution's contention that the defendant is in fact malingering. In support of their insanity defense, the defense has hired Major Shane Riley, a military forensic psychiatrist. In Dr. Riley's report, there's reference to an interview with the defendant's father, who is not a medical health expert, who believes that the defendant's mother may have suffered from some form of mental illness and was institutionalized as a result. However, the defendant's father could not provide any information as to whether the mother had been formally diagnosed, where she was institutionalized, or really where any of this information comes from. We move to exclude any reference to this information as inadmissible hearsay under Federal Rule of Evidence 802. Additionally, this evidence does not meet the admissibility standard under Federal Rule of Evidence 703, which does allow expert witnesses to testify to otherwise inadmissible hearsay. References to this material can be found on the bottom of page 62 and on the bottom of page 65.
Okay, thank you for that. And any response on behalf of defense?
Yes, Your Honor. Under Federal Rules of Evidence 703, an expert testimony or opinion may be relying on facts or data to form an opinion on the subject. Now, the facts or data need not be admissible for the opinion to be admitted. In today's case, Dr. Riley used this interview that she had with Mr. Ray, his father, to come to her expert conclusion. It is necessary to establish Dr. Riley's testimony and give it credibility. Thus, we do think it is admissible under 703.
Oh, Your Honor.
I'll figure this out. Prosecution, if you could go ahead and respond to defense's contentions, and then I'll see if I can try to make a ruling.
While experts are allowed to rely on hearsay, the jury is only allowed to consider that hearsay if the proponent of the evidence, the defense in this case, can prove that the probative value of the evidence substantially outweighs any prejudice, essentially reversing the balancing test under Federal Rule of Evidence 403 and creating a presumption that the evidence is inadmissible. Here, the prejudicial impact of admitting this evidence is high, given the lack of information we have about what type of mental illness the defendant's mother may have suffered from. It would invite the jury to speculate that the defendant's mother suffered from schizophrenia, and that as a result, the defendant is more likely to have suffered from schizophrenia himself. Additionally, Mr. Ray, Mr. Ray's father, is not testifying here today. So we are not going to be able to question him about the source of this information or test the veracity of it. Okay.
Here's what I'm going to do. Given that I appreciate your arguments from both sides and I hear what you have to say, I'm going to go ahead and reserve on this. So when or if it comes up in the middle of your trial, go ahead and let the court know, let me know. We'll go ahead and sidebar, have a discussion, remind me of the objection, and we'll deal with it there. I think I need a little bit more information, a little bit more context when it comes to how this is going to play into the trial itself, and quite frankly, how the expert may rely on it or not. So let's go ahead and reserve on that, but please bring it up when and if it comes up during the trial. All right, any other motions on behalf of the prosecution?
Yes, one more, Your Honor. Our second pretrial motion is to pre-admit Exhibits 6, 7, and 8, each of which has been stipulated admissible prior to trial. This stipulation can be found on page 5 of the record, and the exhibits can be found on pages 53, 54, and 55 of the record.
All right, I'll let a moment for defense to catch up and make sure that we are all on the same page on those exhibits. And then once you guys are finished, let me know and I'll ask if you have any objection to those exhibits being pre-admitted.
Yes, Your Honor. While stipulation 4 does allow Exhibit 6 and 8 as admissible, it does not lay the proper foundation for 7.
All right, let's, just so the scorers have an idea of what we're talking about, could someone just briefly let us know what 6 and 7 are, and then we'll talk about 8. So what is Exhibit 6?
Yes, Your Honor. So Exhibit 6 is the autopsy report of the medical examiner. And
Okay.
then Exhibit 7 is the missing persons report. We have a missing persons report in this case. If you need me to go into further detail, happy to. And then the Exhibit 8 is the Skelton County Department of Corrections, a medical record from the defendant's time in prison.
Okay, so let's, defense, you said that the stipulation was insufficient as to number 8 or Exhibit 8, or am
My
I?
apologies, Your Honor. The updated version does have 6, 7, and 8 on it.
All right. So it sounds like since we've stipulated to that, or you've stipulated to that prior to trial, it sounds like they're coming in. Any other motions in limine on behalf of the prosecution?
No further motions, Your Honor. With that,
Okay.
the prosecution is ready for trial.
Excellent, thank you. Now, defense, do you have any motions in limine? I think you mentioned you may have had one.
Yes, Your Honor, we do have one.
Go ahead whenever you're ready.
Defense anticipates that the prosecution may attempt to enter into evidence Exhibit 10, and this is the defendant's search history the day after the alleged murder. We move to exclude Exhibit 10 under Federal Rules of Evidence 401 and 403. Now, to be relevant under 401, the evidence must have a tendency to make a fact more or less probable in today's case. Today's case deals with first-degree murder. The prosecution must prove Mr. Ray's mens rea at the time of the incident. The incident occurred on October 17, 2018 at 7 a.m. Exhibit 10 does not show the day of the incident, but rather a day later. This search history does not go to show Mr. Ray's mindset at the time of the incident, but rather the consequences that occurred due to his mental break of reality. In addition, we do not know how long of a time span passed between the incident and these searches. While we may see the search happened on October 18th, we do not know what time that search happened. A whole 24 hours or even up to 41 hours could have passed for Mr. Ray to make that search history. And too much time has passed to find that this search history goes to the mindset of Mr. Ray at the time of the killing. The evidence does not go to prove Mr. Ray committed murder. Rather, it shows the day after the incident when Mr. Ray finally comprehended what happened. That is his actions. While the search history may show a callous treatment of a corpse, this is not a charge for today's case. It's a charge of first-degree murder, not the improper disposal of a corpse. Exhibit 10 does not go to prove intent of Mr. Ray in the moment of the incident. However, even if you find the evidence to be relevant under Federal Rules of Evidence 703, the evidence should still be excluded. Federal Rules of Evidence 403 allows relevant evidence to be excluded if the probative value is substantially outweighed by the danger of unfair prejudice. Rather than any probative value, the evidence will substantially unfairly prejudiced the jury by misleading them into a guilty verdict, a verdict against my client. As stated, the search history occurred after the fact. Allowing Exhibit 10 into evidence would allow the jury to make an improper inference as to the state of mind Mr. Ray had at the time of the incident. It does not go to show Mr. Ray's intent, but rather hours after the event. And thus, under Federal Rules of Evidence 401 and 403, defense asks that Exhibit 10 be excluded. Thank you.
All right, any opposition to the defense's motion?
Yes, Your Honor. Exhibit 10 has a highly probative value here. The ultimate issue in this case is going to be whether or not the defendant knew right from wrong at the time that he murdered his son. This goes directly to the defense's claim that he was insane and unable to understand the wrongfulness of his actions. Exhibit 10 was conducted the day after the murder, like opposing counsel stated. However, this is circumstantial evidence that the defendant understood his actions were wrong. If as an offer of proof, if this is allowed to come in, these searches state that on the defendant's phone that were Google searches asking how to get rid of a body, will bleach destroy a body, in countries that don't extradite from murder charges. The prosecution, it's our prosecution's argument that this is circumstantial evidence that the defendant understood his actions were wrong at the time of the murder.
All right, defense, I'll give you one last chance to respond.
Your Honor, as I reiterate, the evidence does not go to show at the time of the incident. The search history did not happen during the killing. Rather, it happened almost a day later. This doesn't go to show Mr. Ray's mindset and would only be used to prejudice the jury into deciding that it is. And thus, we do request that Exhibit 10 be excluded.
Any last minute responses by the prosecution?
Yes, Your Honor. Apologies. There's a siren going by. So yes, the prosecution would like to state further that this goes to weight and not admissibility. If the defense rather is free to cross-examine our witness, Detective Booth, on this information. However, this information is highly probative. It gives the jury the chance to see that the defendant was within the state of mind to type in these Google searches, to realize that what he had done was wrong and that he needed to hide it.
All right, this one, my ruling is going to be to admit it for many of the reasons you stated, but primarily actually because of, if I recall, when we were drafting jury instructions in chambers days ago, I'm sure you all remember, that one of the jury instructions talks about, I think, the defendant memory or history, mental history can be considered, the jury can consider it before and after the offense. This does seem to be after. I do understand defense's argument that the argument is many more hours, if not days after, but I also understand the prosecution's argument that this is relevant to go to show to his mental state, in which, from what you've explained to me and from my understanding of this, we're going to be talking about how the defendant was acting a couple days after the incident itself. So something that happens in between, I see it relevant. Obviously, defense, if you think the prosecution is using it improperly or you'd like to renew your objection, please do so. Remind the court. We can, again, consider it before it is introduced in front of the jury. All right. Any other motions eliminate on behalf of defense?
No, Your Honor. At this time, defense is ready to proceed.
All right. Then what I will ask, if I'm sure you already know as advocates, for those of you who are not doing the opening and not presenting, if you could mute your video and audio. Those of the person that is, go ahead and leave obviously your audio and video on. And if you have an objection, as opposing counsel is doing their opening, then put on your video, unmute yourself so that we can go and hear you. Otherwise, let's focus on the advocate who is doing the opening, right? Whenever you're ready, please proceed.
When Jessica Ray went to pick up her son Nathan from school on October 18th, 2018, and she was told he wasn't there, she tried not to think the worst. Nathan was probably just with his dad. When Jessica went to the dad's house and Nathan wasn't there, she tried not to think the worst. Nathan's dad probably just took Nathan somewhere as a way to get back at her. Then she gets the call that's every parent's worst nightmare. It was the police calling to tell her that they had found her 6-year-old son's body in a local park, and that the defendant, the boy's father, had confessed to the murder. During this trial, there will be a couple issues for you to decide. One is whether the defendant, Timothy Ray, is guilty of murdering Nathan. And by the end of this case, it will be clear that the answer to that question is yes. The other is whether Mr. Ray was suffering from a mental disorder that caused him not to understand that his actions were wrong, or from just not understanding what he was doing. And by the end of this case, it will be clear that the answer to that question is no. The evidence you'll hear today will lead you to those answers by establishing two things. First, the defendant knowingly killed his son by strangling him to death. And second, the defendant understood that killing his son was wrong. So let's talk about that first thing. The evidence will show that the defendant knowingly killed his son by strangling him to death. The morning of Nathan's murder started like most other days, with Nathan eating his favorite cereal while enjoying a cup of apple juice. And 6-year-olds doing what 6-year-olds do, Nathan spilled apple juice right on the defendant's laptop. And while kids spilling juice is common, the defendant's reaction was anything but normal. The defendant started screaming at the boy so much that Nathan burst into tears and ran upstairs to his room. Still screaming and yelling, the defendant follows Nathan upstairs and forces him to do exercises as punishment. Eventually, little Nathan's body can't take it anymore, so he stops exercising and begins calling for his mother to help him. But she's not there. She can't hear him. But the defendant can. And hearing Nathan scream for his mother is the last thing the defendant wants to hear, so he storms off to his bedroom where he grabs a belt from his closet and returns to quiet his inconsolable son. He walks into the room and hits Nathan with the belt a few times. But Nathan just won't stop screaming. So the defendant does something that forces Nathan to stop screaming for his mother. He takes the belt, wraps it around the boy's neck, and squeezes. Nathan gasps and struggles for his last breath, and suddenly, silence. Nathan's 44-pound body goes limp. And after taking the life of his only child, the defendant was faced with the issue of what to do. So he begins looking for ways to hide what he'd done. That brings me to the second thing the evidence will show, that the defendant understood that killing his son was wrong. During this trial, you'll learn that the defense is claiming that Mr. Ray suffered from schizophrenia so severe that he didn't understand that killing his son was wrong. But his actions after killing Nathan will show you that's simply not true. After strangling his son to death, you'll get to see the internet searches the defendant conducted, looking for ways to get rid of a body, and countries that don't extradite people for murder. You'll also learn that ultimately the defendant tried to hide Nathan's body by placing it in a black trash bag and burying it in a makeshift grave in Brandywine Park. Unfortunately for him, the defendant was stopped at a DUI checkpoint 2 days after killing Nathan, with the shovel and the plastic bags he used to hide Nathan's body still in the backseat of his car. You'll also learn that once the police had the defendant step out of the car at the checkpoint, the defendant started acting strangely. An attempt by him to make it look like he was suffering from severe mental disease. But today, you'll hear from Dr. Mac LaGreca, an expert forensic psychiatrist with 25 years of experience evaluating people for mental illness. And what Dr. LaGreca will tell you is simple. She'll tell you that while the defendant was suffering from anxiety and depression, both of which are recognized mental illnesses, that based on the evidence, it will be clear that the defendant's mental illness wasn't nearly severe enough to keep him from understanding what he was doing as he strangled Nathan, or from understanding that it was wrong. Dr. LaGreca will also tell you that based on her review of the defendant's medical records and all of the facts of this case, he was malingering, which Dr. LaGreca will tell you is just a psychiatrist's way of saying he was faking his symptoms. Members of the jury, after seeing all of the evidence and hearing all of the testimony in this case, it will be clear that the defendant murdered his son out of anger and not because of any mental illness. That's why at the end of today's trial, my co-counsel will come before you and ask you to return the only verdict consistent with the law and demanded by the facts, a verdict finding him guilty of murder.
Thank you very much. Defense, do you wish to make an opening statement?
Yes, Your Honor.
Proceed whenever you're ready.
May it please the court, counsel, members of the jury. You cannot stop what you cannot control. Timothy Ray could not stop his mother from developing a mental illness. Timothy Ray could not stop his mother from torturing him as a child. Timothy Ray could not stop the mood swings and mental breakdowns that forced the love of his life to leave him. Timothy Ray could not stop the fact that every single person that he interacted with missed the signs. And on October 17th, 2018, Timothy Ray could not stop the creepy voices that led to the death of his son. Timothy tried and failed because he could not stop what he could not control. Now, the state just got done telling you what Timothy Ray is. I would like to tell you who Timothy Ray is. From the age of 3, Timothy Ray has been fighting against the odds. While most children grow up in loving and nurturing homes, Timothy experienced the opposite. Instead, he grew up with a mother who was neglectful and abusive. A mother who, while suffering from mental illness, refused to feed her child. A mother who chose to bathe her child in ice-cold water. A mother who chose to abandon her child when he was just 3 years old. But now that his mother is gone, the effects of the abuse and neglect still remain. At the age of 10, Timothy began hearing voices that would come and go throughout the years. Timothy would try to hide these voices out of fear of being labeled crazy like his mother. But the voices persisted. Timothy tried to move on and serve his country. But despite his efforts to move on from his childhood, Timothy was soon discharged after reports from his commanding officer that Timothy was suffering from anxiety, depression, and hallucinations. Timothy was once again left alone. Alone until he met the love of his life, Jessica Ray. The two met in 2011 while they were both working at a computer store. The two married soon after, and things were looking good. The two even gave birth to a young boy named Nathan. But even Timothy's love for Jessica and his son was not powerful enough to overcome his mental illness. Over their relationship, Timothy would suffer from mood swings, recurrent racing and negative thoughts, and visual and auditory hallucinations. Jessica would tell Timothy to get help for these mental problems, but despite her efforts, Jessica was forced to sit and watch as the person she loved turned into someone that she could not even recognize. And after 6 years of marriage, that marriage ended. Now all Timothy has left is his boy, Nathan. But in the months leading up to October 2018, the hallucinations returned. Timothy saw triangles on the walls that changed shapes and colors. He heard a male voice that told him to hurt other people. And on October 17th, 2018, Timothy heard a creepy voice that told him to kill his son. And like that, the last thing in Timothy's life was taken from him. So who is Timothy Ray? Timothy Ray is a man in pain, a man that to this day is still grieving over everything that this disease has stolen from him ever since he was a kid. A man forced to live with a mental illness that went unnoticed, untreated, and was therefore uncontrollable. Members of the jury, my name is Braden Hodak, and I, along with my co-counsel, Ms. Jessica Allen, represent Timothy Ray. Now, I'd like you to recall our discussions in jury selection when we talked about the burden of proof in this case, and how the state must prove to you beyond a reasonable doubt that Timothy Ray possessed hatred in his heart at the time Nathan Ray was killed. Imagine the burden this way. There's a set of scales in front of you. On one side sits an elephant, the largest one you can think of. On the other side is nothing yet. Now imagine someone placing rocks of various sizes on the other side of that scale, and imagine the scale move. The elephant never leaves the scale at any point in time. Timothy Ray is that elephant. He is innocent until proven guilty. The state has the burden of placing rocks on the other side of the scale or pieces of evidence to tip the scales, and to find Timothy Ray guilty. The scale must lift the elephant so high that the other end of the scale is barely skimming the ground. Members of the jury, at the end or at the close of trial, my co-counsel, Ms. Jessica Allen, will stand before you. When she does, she will discuss with you the facts that we have discovered together, the law that the judge will provide, and she's going to ask you to look at the facts and look at the law through your own common sense. And we are confident that if you look at the facts and look at the law through your own common sense, you will be given no other option than to find that Timothy Ray did not have control, and that Timothy Ray is innocent, because he is.
Thank you very much. And if you need to take a moment before calling your first witness, that's fine. But whenever the prosecution is ready, please call your first witness.
Yes, Your Honor. Prosecution calls Detective Blake Booth to the stand.
All right, Detective Booth, you've been sworn in constructively. What I'm going to go ahead and do is mute my video. And then if there's a ruling that comes up, let me know, just so that the jurors can focus on you two. I was going to do that in opening, but since I didn't do it for the one side, I didn't want to be unfair. So I'll mute my video. If there's an objection, I'll come back to the screen so the jurors can just focus on the two advocates. All right, whenever you're ready, please proceed.
Good morning. Please introduce yourself and tell us where you're from.
Good morning. My name is Detective Blake Booth, and I'm from here in Skelton.
What do you do for a living?
I'm a detective for the homicide unit at Skelton Police Department.
How long have you worked for Skelton PD?
For over 23 years now.
Detective Booth, how did you become involved in this case?
On October 19, 2018, I received a call that a suspect was stopped at a DUI checkpoint. So I went down to the checkpoint and spoke with the officers, where I discovered he was a suspect in a missing persons case I was assigned to. And then I had the suspect taken back to the station for an interview.
Your Honor, I have the missing persons report Detective Booth just mentioned that has been marked into evidence as Exhibit 7 and has been pre-admitted. Permission to publish the exhibit for the jury?
Assuming no objection, or is there any objection from defense? I believe this is one that was stipulated and we addressed regarding its admission. Hearing no objection, I'll give a moment.
No objection, Your Honor.
Okay, thank you. Then we'll go ahead and publish to the jury.
Detective Booth, do you recognize Exhibit 7?
Yes, I do.
What is it?
It's a report from the missing person case that I was just talking about. I wrote it after receiving a call from Jessica Ray, Nathan's Ray's mother, who was the boy missing in this case.
Did she say where Nathan was supposed to be?
Yes, she told me that Nathan was staying with his father, but that he hadn't been to school for a few days. And so she said that she was calling him and he stopped returning her calls. And they were separated and weren't on good terms. So she just thought Mr. Ray was trying to keep Nathan away from her.
Detective Booth, did you know Nathan before you became involved in the investigation?
I did. Nathan and my son played on the same soccer team.
Would you recognize a picture of Nathan if you saw it?
I would.
Your Honor, I have a photograph that has been pre-marked as Exhibit 29 for identification. This item can be found on page 106 of the record. Detective Booth, do you have a copy of Exhibit 29 for identification?
I do.
Do you recognize it?
Yes.
What is it?
This is a photograph of Nathan Ray.
Is Exhibit 29 a fair and accurate depiction of Nathan before his death?
Yes, it is.
Your Honor, prosecution moves Exhibit 29 into evidence.
Any objection on behalf of defense?
Yes, Your Honor.
Go ahead.
This photo is substantially more prejudicial than it is probative. There's nothing in this photo that Detective Booth cannot testify to, even as to identification of Nathan Ray, which is what I'm guessing the prosecution is using this photo for. So Detective Booth can testify to this. The only purpose of this is to inflame the passions of the jury in order to prejudice them against the defense by putting a photo of a 6-year-old up for the jury to see.
I'm assuming that we're outside the presence of the jury. So remember, ask the first time, and then from there we don't have to. But prosecution, what is your response to the defendant's objection, or defense objection?
Your Honor, this is a photo of the murder victim.
But when it comes to the defense's argument that this is going to inflame the passions of the jury, what is your response to that?
The jury should have the opportunity to see the 6-year-old boy that was murdered by his father. It's part of our responsibility to prove that beyond a reasonable doubt that the defendant killed his son. And this is his murder victim. This is who he killed.
Defense, what's your response to that the prosecution has an obligation to fulfill their elements? Do you have a response when it comes to how, if at all, this relates to an element or the burden that they have to overcome?
Yes, Your Honor. When it comes to identification of Nathan Ray, Detective Booth can testify to that. And as we've already admitted, was the autopsy report that Detective Booth can also testify to. These are two ways that the prosecution can satisfy their elements without the risk of unfair prejudice that this photo would bring.
Here's what I'm going to do. I'm going to allow it for now. And if you think, defense, if you think that the prosecution is improperly using it or improperly in argument or however they may use it, please renew the objection to let us know. And we'll go ahead and consider it at that point. But I think it still survives the analysis so far. So I'm going to let it in for now. But if you, for some reason, you think they're arguing it improperly, prosecution, you run the risk of having evidence being introduced that later on, if the argument is improper or it's being used improperly just to inflame the passions of the jury, you do run the risk of then it being excluded. So we'll go ahead and admit it outside back in front of the jury. Let's go ahead and continue.
Permission to publish the exhibit for the jury?
Granted.
Detective Booth, who was the person you brought in for questioning?
Nathan's father, Timothy Ray.
Did you see Timothy Ray here in the court screen today?
Yes, I did.
Could you describe him to us and tell us what he was wearing?
He had brown hair, was wearing a white shirt and a blue tie.
Your Honor, may the record reflect that the witness has identified the defendant.
Yes, it will. Thank you.
Detective Booth, you said earlier that you had the defendant taken down to the station so you could interview him. Did you interview him?
Yes, once we got down to the station, he agreed to talk to us about the disappearance of his son.
And where did he say Nathan was?
He told me that he killed Nathan on October 17, 2018.
Did he tell you why?
Yes. He said that he and his son were having breakfast that morning and that his son spilled apple juice on his laptop. The defendant said he killed Nathan while punishing him for spilling the juice.
What exactly did the defendant say happened after Nathan spilled his juice?
He started yelling at Nathan. Nathan started screaming and crying and ran to his bedroom. So the defendant followed him up to his room and started making him do exercises as punishment.
What kind of exercises?
Jumping jacks, running in place, and high knees, which is where you run in place, but you bring your knees up really high.
What else did the defendant say?
He said that after a while, Nathan refused to do any more of the exercises, and he just kept screaming and crying for his mother. So the defendant said that he went to his room, grabbed a belt, and started spanking Nathan with it.
What did the defendant say happened after he started hitting his son with a belt?
Nathan was screaming for his mother, so the defendant grabbed the belt, wrapped it around his son's neck, and squeezed it, strangling him until he stopped moving.
And what did the defendant do with Nathan after he stopped moving?
He said he took his body and buried it at Brandywine State Park.
Thank you, Mr. Khan. You can take down the exhibit now. Was this interview recorded?
Yes, it was. It was audio and video recorded.
And do you still have a copy of those recordings?
No, I don't have the recording saved, but I have a transcript of our interview.
Detective Booth, after the interview, what did you do?
I took a team of officers and a K-9 unit to search for Nathan's body at Brandywine State Park.
And how long did you search the park for?
It was about an hour and a half before one of the dogs found Nathan wrapped in trash bags and buried under some trees.
Your Honor, I have a photograph that has been pre-marked as Exhibit 18 for identification. This item can be found on page 95 of the record. Detective Booth, do you have a copy of Exhibit 18 for identification?
Yes, I do.
Do you recognize it?
I do.
What is it?
This is a photograph of Nathan's body as we found it at Brandywine State Park.
Is Exhibit 18 a fair and accurate depiction of Nathan's body as you discovered it in the park?
Yes, it is.
Your Honor, prosecution moves Exhibit 18 into evidence.
Any objection on behalf of defense?
Yes, Your Honor.
Go ahead.
Can I call a constructive sidebar?
I'm muted. Yes, thank you.
Your Honor, this photo is substantially more prejudicial than it is probative. Here, Detective Booth can also testify to the scene of the crime, the body, and the identification of the body within this photo. Additionally, there is no picture of a body in this photo, just something in a bag, and therefore does not assist the prosecution in identifying the body.
Prosecution, your response to that?
Your Honor, this is direct evidence that the defendant understood that killing his son was wrong. The major issue in this case, he hid his actions, which is circumstantial evidence of understanding the wrongfulness of your doings. Now, it corroborates what the defendant told the detective officer about how he disposed of Nathan's body. So the jury can come to the conclusion that in that plastic bag is Nathan.
My understanding also that there's a stipulation that the exhibits are deemed authentic and are what they purport to be. Is that a stipulation the parties entered to prior to trial? So I assume some nodding heads. Okay. Defense, I'll give you one more shot when it comes to the, I guess you would say, relevance portion of it, outside of it being what it purports to be. If you could go ahead and argue that, and I'll give you one last shot.
Your Honor, it'll be the same argument. Detective Booth can testify to this. They have the autopsy report. They have his testimony to identify it. And as I said, there is no body in this photo. So all the prosecution is trying to do is parade this photo in front of the jury to get them to imagine a 6-year-old body in this trash bag, which will substantially prejudice the defense.
Okay, I'm going to go ahead and allow it in. I think it's a little bit different than the picture of Nathan as he is by himself. that seems to corroborate, as prosecution laid out, some of the defendant's actions and statements. But again, if for some reason you think it's being argued improperly, let us know. But at this point in time, I'm going to go ahead and overrule the objection.
Permission to publish the exhibit for the jury?
Granted.
Detective Booth, you said earlier that the defendant was driving a car when he was stopped at the sobriety checkpoint. Was that car ever searched?
Yes, I searched the defendant's car where I found the bleach bottles, plastic trash bags, and a shovel in the back seat.
Your Honor, I have photographs that have been pre-marked as exhibits 22 through 26 for identification. These items can be found on page 99 through 103 of the record. Detective Booth, do you have a copy of exhibits 22 through 26 for identification?
Yes, I do.
Do you recognize them?
Yes.
What are they?
They're the photographs of the items that were found in the back of the defendant's car.
Are these exhibits a fair and accurate depiction of the items found in the defendant's back seat as you first saw it?
Yes, it is.
Your Honor, prosecution moves exhibits 22 through 26 into evidence.
Any objection on behalf of defense?
Yes, Your Honor.
All right, go ahead and state your grounds, please.
Your Honor, I don't see how these photos are relevant to the prosecution's elements that they have to prove here. These are found in the defendant's cars 2 days after the event, which is a substantial time after the issue here, which is at the time of Nathan's death.
Prosecution, your response.
Your Honor, this is directly relevant to our case. This shows the calculations the defendant took to get rid of his son's body. Not only does it prove beyond a reasonable doubt that he murdered his son, it also shows that he understood the wrongfulness of his actions by trying to get rid of his son's body.
Any last response on behalf of defense?
Getting rid of the body is not an element of the crime, Your Honor.
Okay. At this point, I'm going to go ahead and overrule the objection and permit it to be published to the jury, as I imagine you may be asking, and we can proceed.
Detective Booth, were the park and the defendant's car the only things you searched in your investigation?
No, I also searched his house as well as his cell phone.
Let's talk about your search of the defendant's phone first. Did you find anything there that was significant to your investigation?
Yes, I found a number of internet searches on the defendant's phone the day after he killed his son.
Your Honor, I have a photograph that has been pre-marked as Exhibit 10 for identification. This item can be found on page 57 of the record. Detective Booth, do you have a copy of Exhibit 10 for identification?
I do.
Do you recognize it?
Yes.
What is it?
It's a screenshot of the internet searches that I just mentioned that were found on the defendant's phone the night he was arrested.
Is Exhibit 10 a fair and accurate depiction of what you found in the defendant's phone search history?
Yes, it is.
Your Honor, prosecution moves Exhibit 10 into evidence.
All right, this one, I think there will definitely be an objection on behalf of defense, given the motion to eliminate discussion. Defense, assuming there is an objection, let's go ahead and address that.
Yes, Your Honor. At this time, the defense would renew its objection made during the motion to eliminate. Understanding that the court will overrule this objection, I would ask for a standing objection to these exhibits and any lines of questioning that result from the admission of these exhibits.
To be clear, I'm not necessarily overruling it. I just wanted to make sure that when it was brought up that you could renew it and make any additional arguments. Do you have any additional arguments that you would like to make when it comes to its admissibility?
No, Your Honor.
Okay, prosecution, any argument?
Your Honor, these Google searches have been, they've been stipulated that it shows that 3 Google searches were conducted on October 18th. This is all circumstantial evidence that the defendant made these searches on his phone after killing his son, showing that he understood that it was wrong. Any objection that the defense has to this exhibit goes to the weight and not the admissibility.
Understood. I'll go ahead and overrule the objection and permit the exhibit to be entered into evidence. And if you'd like to, it can be published to the jury.
Detective Booth, you said you also searched the defendant's house. Where does the defendant live?
Here in Skelton.
Did you find anything there that was significant to your investigation?
Yes, I found evidence of the juice spill that the defendant mentioned, and I also found a grown man's belt lying on the bedroom floor in Nathan's room.
Your Honor, I have a photograph that has been pre-marked as Exhibit 27 for identification. This item can be found on page 104 of the record. Detective Booth, do you have a copy of Exhibit 27 for identification?
I do.
Do you recognize it?
Yes.
What is it?
It's a photograph of the belt we found in Nathan's bedroom.
Is this exhibit a fair and accurate depiction of the belt as you found it in Nathan Ray's bedroom?
Yes, it is.
Your Honor, prosecution moves Exhibit 27 into evidence.
Any objection on behalf of defense?
Yes, Your Honor. The probative value does not outweigh the prejudicial value of this photo. This is simply just a photo of a belt. It doesn't go to prove any element of the crime. And again, prosecution is just trying to parade it in front of the jury in order to inflame the passions of the jury to prejudice the defense.
Response on behalf of the prosecution.
Your Honor, this is not a photo of just any belt. This is the murder weapon that the defendant used and testified to when he talked to the detective about how he killed his son. We still, as the prosecution, have the burden to prove to the jury that the defendant killed his son beyond a reasonable doubt.
Defense?
Detective Booth can testify to the belt. It's already established in his testimony. There's no need for this photo in order to prove that.
Understood. At this point in time, I'm going to overrule the objection and it will be admitted. Should you wish to publish it, you may go ahead and do so.
Detective Booth, did you do anything else? Did you do any further investigations?
No.
No further questions, Your Honor.
Thank you. And any cross-examination for this witness?
Yes, Your Honor.
All right, begin whenever you are ready.
Detective Booth, you were lead detective on this case.
That's correct.
You decided how the case was investigated.
Yes.
You decided what evidence to collect.
That's correct.
You decided what suspects to interview.
Yes.
Timothy Ray was your only suspect during this investigation.
That's correct.
You knew Timothy Ray before this encounter?
I did.
Both of your kids played on the same soccer team?
Yes.
While attending your kids' soccer events, you've had strange interactions with Timothy before.
A few.
Timothy acted socially awkward.
You could say that, yes.
He appeared uncomfortable.
In the brief interactions we had with him, he did appear a little uncomfortable.
It was hard for him to hold a conversation.
Yes.
He looked generally unkempt.
Yes.
He had a scraggly beard and appeared dirty.
That's correct.
Timothy Ray didn't fit in with the other parents.
I'm not sure if he was able to fit in with the other parents, but I didn't really have that much interaction with him.
Detective Booth, I'd like to talk to you about your training. Have you received any specific mental health training?
Not any formal training, but being 23 years on the force, I've had my share of training in the field.
Can you name any of the psychiatric signs of schizophrenia?
No, I'm not a doctor.
Detective Booth, during your interview with Timothy Ray, he was not acting strange.
No, he was not.
Timothy asked you if you were with the CIA.
That's what he said initially, but after that, he knew who I was.
He did know who you were.
Yes.
Timothy referred to quote unquote they.
He said it a couple of times.
You didn't ask Timothy to clarify who he was talking about.
No, I didn't, because when we started the interview, I asked him if anyone else was there with him, and he only mentioned himself and Nathan.
Timothy said to you he didn't mean to kill his son, correct?
That's correct.
You notified Jessica Ray, Timothy's wife, about this incident?
I did.
To the best of your knowledge, you were the first person to notify Jessica Ray.
That's correct.
She appeared shocked,
Yes.
started crying uncontrollably.
Yes.
She said to you, I knew I should have never left Nathan alone with him when he was acting strange. I knew he was going crazy.
Objection, Your Honor, hearsay.
Response?
Your Honor, this falls under the excited utterance exception under Rule 8032.
Response on behalf of the prosecution.
Submitted on our prior argument.
All right, going to go ahead and overrule the objection and permit it. Please continue.
That's what she said at that time. But initially, when I spoke with her and she filed the missing persons report, she just thought Timothy was trying to keep Nathan away from her.
But at that moment, that is what she said to you.
At that time, yes.
Detective Booth, the Skelton Police Department has specific directives for collecting evidence.
They have guidelines, yes.
These directives tell you to preserve evidence.
They do.
This interview was recorded,
It was.
but you did not retain a video copy.
Not the video, but I did retain the transcript of the interview.
Is it possible that you missed body language and speech patterns that would indicate Timothy was suffering from a mental illness?
I'm sorry, is it possible if I missed that?
Yes.
No, I don't think that's possible.
Detective Booth, you can't name any of the psychiatric signs of schizophrenia?
No, like I said, I'm not a doctor.
No further questions.
Thank you. Any redirect on behalf of the prosecution?
No, Your Honor. May this witness be excused?
Yes. All right, when the prosecution, when you are ready, go ahead and call your next witness.
Prosecution calls Dr. McLagreca to the stand.
Thank you. All right, hi there, Dr. LaGreca. Whenever you're ready, you've been sworn in constructively. Whenever you're ready, counsel, go ahead and proceed.
Good afternoon. Please introduce yourself to the jury and tell us what you do for a living.
Hello, my name is Dr. McLagreca, and I am a forensic psychiatrist and the program director of the West Carolina School of Medicine's Forensic Psychiatry program.
What's a forensic psychiatrist?
A forensic psychiatrist is a physician. We use our medical training to consult with patients, their attorneys, and sometimes courts to provide expertise about mental health issues that come up in a legal context.
What do you do as program director for West Carolina's Forensic Psychiatry program?
I teach and supervise fellows in the forensic psychiatry program. I also oversee medical students in their general psychiatry rotation, and I'm also continuing to treat patients myself.
Please tell the jury about your education.
I earned my medical degree from the University of Pennsylvania and completed my psychiatry residency at UCLA. I then returned to UPenn to complete my forensic psychiatry fellowship.
You said you continue to treat patients today. Did you practice as a psychiatrist before moving into academia?
Yes. After I graduated and completed my training, I began my own private practice in New Jersey, where I treated patients with a variety of mental disorders.
How long did you practice?
23 years before I moved into my current position in 2017.
Have you ever been published?
I'm currently working on a paper on malingering arising in criminal cases involving capital punishment. It has yet to be published.
What's malingering?
Malingering means faking or exaggerating an illness. It's a term that psychiatrists use to describe a person who's faking or exaggerating mental health symptoms.
Are you a member of any professional organizations in the field of psychiatry?
Yes, I'm a member of the American Medical Association and the American Academy of Psychiatry and the Law. I'm also a member and past president of the American Psychiatric Association.
Do you have any board certifications or licenses?
Yes, I'm board certified in forensic psychiatry and licensed in 3 states, New Jersey, West Carolina, and the Commonwealth of Pennsylvania.
Have you testified as an expert before?
Yes, 7 times.
Your Honor, at this time, the prosecution tenders Dr. Mac LaGreca as an expert in forensic psychiatry.
Any objection, or does defense have a wish to voir dire? Either one.
Yes, Your Honor. At this time, defense does object under Federal Rules of Evidence 702 and request to voir dire on the issue.
All right, whenever you are ready, go ahead and proceed. And then once you are done, obviously let us know, and we'll go ahead and handle the ruling then.
Yes, Your Honor. Dr. LaGreca, the DSM-5 is the authoritative source for your opinion today. Is that correct?
That's correct.
It's the principal method that you relied on.
That's correct.
Now, in the DSM-5, there are 4 factors that are memorialized for malingering.
Yes, that's correct.
The first one is medical legal context of the evaluation.
Right.
And you found that Major Riley's clinical assessment happened during Mr. Ray's conviction.
Yes, that's correct.
The second element was marked discrepancies between the patient's claim stress or disability and the objective finding.
Yes, that's correct.
You found discrepancies in Mr. Ray's clinical interview.
That's correct.
The third element is the lack of cooperation during the diagnostic evaluation and in complying with the prescribed treatment regimen.
That's correct.
You found Mr. Ray was not cooperative during his clinical interview.
That's correct.
Now, the final element is an antisocial personality disorder.
Yes.
And there was no presence of this in today's case.
I'm not sure you could say that there was no presence about that.
Now, Dr. LaGreca, evading criminal prosecution is not memorialized in the factors for the DSM-5.
I'm sorry, can you repeat that?
Evading prosecution is not memorialized as a factor in the DSM-5.
Those specific words are not, but being evaluated in a medical legal context is one of the external gains that someone could use as one of the reasons for malingering.
However, Dr. LaGreca, bringing you back to my question, criminal evading prosecution is not a factor that is memorialized in the DSM-5.
Those are not the exact words.
You used this factor in coming to your conclusion today?
I used the fact that the patient was uncooperative in the interview, that he also had some discrepancies between his claimed symptoms and the symptoms he actually exhibited, and also the fact that his evaluation, Dr. Riley's evaluation, occurred in 2019, which was after he had been arrested.
So you did not consider evading criminal prosecution in coming to your conclusion today?
Evading criminal prosecution is one of the things that was considered because this was in a medical legal context. If Timothy Ray were to be diagnosed with schizophrenia, this would be one thing that would support an insanity defense.
Dr. LaGreca, bringing you back to my question, did you or did you not consider evading criminal prosecution as a factor for malingering?
Yes.
Now, Dr. LaGreca, you cannot testify to any peer-reviewed publication articulating evading criminal prosecution as a factor for malingering.
I'm actually currently working on a paper on malingering.
That is not published, though, is it?
No, it's currently in the process.
So currently, there are no publications articulating evading criminal prosecution as a factor?
Not currently. I actually spent most of my time in private practice.
Dr. LaGreca, you cannot testify if this additional factor is generally accepted in the scientific community currently.
Can you clarify as to what specific factor you mean?
The evading criminal prosecution.
I think that that's implied in the DSM, which states that in a medical legal context.
However, bringing you back to my question, Dr. LaGreca, the evading criminal prosecution is not memorialized in the DSM-5 factors for malingering.
No, not those specific wording.
Your Honor, at this time, defense renews our 702 objection. Dr. LaGreca should not be admitted as an expert in forensic psychiatry due to Dr. LaGreca's failure to reliably apply the proper principles and methods to the facts of the case. As established by voir dire, while coming to her conclusion, Dr. LaGreca failed to form a product of reliable methods, and her opinion was not sufficiently grounded in scientific methodology. Dr. LaGreca's additional factor is not an accepted, published, peer-reviewed factor for malingering and would unduly influence the jury. Simply due to the witness being labeled as an expert, the jury will give more weight to Dr. LaGreca's testimony. By adding that additional factor, Dr. LaGreca's steps in rendering her analysis becomes unreliable. Now, if there's any unreliable part of analysis, this renders the expert's testimony inadmissible. This applies whether the step completely changes a reliable method or merely misapplies the methodology. In today's case, we see that this occurred, and the defense asked the court to exercise their role as gatekeeping to limit Dr. LaGreca's testimony to not include such opinions on malingering, specifically the additional factors she reviewed.
Prosecution, your response.
Yes, Your Honor. Again, we have established, given Dr. LaGreca's 25 years of experience, her clinical experience, that she is in fact an expert in forensic psychiatry. She is a member of multiple professional organizations, has incredible, has board certifications as well. As far as malingering is a definition memorialized in the DSM that opposing counsel was referring to. And in that definition of malingering, those are factors. They're not almost like elements in a legal sense. So she doesn't have to, in order to conclude that the defendant was malingering, Dr. LaGreca does not have to find that every single factor applied in this case. It's really more of an expert opinion. In the forensic psychiatry field, malingering is an important factor. It's something that all forensic psychiatrists must address, given the fact that they are in a legal context. This is factor one. And the other factor that Dr. LaGreca will testify to is the discrepancies. There are numerous discrepancies between what the defendant claimed he was suffering and from the objective findings in this case. Therefore, she is more than qualified to testify and give her an opinion on whether or not the defendant was malingering himself.
Any last words on behalf of defense?
Yes, Your Honor. While a factor does not have to be all present for a malingering opinion, we are talking about the fact that Dr. LaGreca added an additional factor. She misapplied the methodology that is in her field of practice. And because of that, it makes Dr. LaGreca's testimony inadmissible due to her applying the methodology incorrectly. And thus we ask that you limit her testimony.
All right, I appreciate your well thought out arguments on both sides. I think this issue is one circumstance of weight, not necessarily admissibility, so to speak. So any of those issues, you are obviously free to argue and argue away when it comes to closing or if there's further cross. But at this point in time, I'm going to go ahead and overrule the objection, and she will be permitted to testify as an expert. Anything further on behalf of defense before we continue on with the direct examination?
No, Your Honor.
All right, please continue.
Dr. LaGreca, turning your attention to this case, how did you become involved?
I became involved because prosecution asked me to review the case and to give an opinion on whether or not Mr. Ray was suffering from a severe mental illness at the time he killed his son.
Are you being paid for your work on this case?
Of course. I'm being paid my normal rates, which are $500 an hour to review the case and to prepare a written report, and a flat rate of $1,750 per day for my time in court, which includes my travel, lodging, and my meals.
What specifically did you review for this case?
I reviewed the police reports and the crime scene photographs, the witness statements, the defendant's medical records, the report prepared by the defendant's expert, Major Shane Riley, and the DSM-5.
Dr. LaGreca, you said that you relied on a report you said that you reviewed a report prepared by the defendant's psychiatrist. Were you able to interview the defendant?
No, I requested to interview him, but Mr. Ray's attorneys refused to produce him for evaluation.
Objection, Your Honor. Under 403. as well as a Fifth Amendment issue, Your Honor. May I respond?
Yes, if you could clarify that, please.
Your Honor, under 403, this questioning is more prejudicial than probative. It does not go to an element of today's case. In addition, Mr. Ray does not have an obligation to be interviewed by Dr. LaGreca. He is allowed to stay silent as he sees fit. That is his right. Bringing up the fact that he does not talk to a certain doctor is inappropriate to bring forth and could come forward as a mistrial in today's case.
Prosecution.
Yes, Your Honor. While the defendant certainly has his Fifth Amendment right to refuse to speak to our psychiatrist, we are bringing this up because for Dr. LaGreca's credibility in this case, we have a good faith belief that the defense will try to undermine her credibility, that she herself was not able to interview the defendant, and therefore her conclusions are less reliable than their expert. Therefore, we will, as an offer of proof, if allowed to testify, this expert witness will only testify that she was not allowed to testify and that she was not allowed to interview the defendant, but that did not have an effect on her opinion. So this is to establish Dr. LaGreca's credibility.
All right, so what I really is gonna be as follows. I'm gonna allow this line of questioning. However, depending on how it's argued in closing, it would be improper to start arguing, well, they didn't let their client talk to our witness, so what does he have to hide type of argument. So when it comes to the doctor's qualifications and background and how she came to her opinion, I think that's relevant because she doesn't have this piece of information. But again, if it starts getting into, well, what does he have to hide? He should have been talking to everyone. That may be crossing the line. So defense, your argument is well taken. So listen in to see if they cross that line. If you think they do, feel free to object. And especially in closing, if you think they cross that line, then let the court know and we'll handle it at that point. Otherwise, objection at this point is overruled.
Yes, Your Honor.
Dr. LaGreca, you said you reviewed a report prepared by the defendant psychiatrist. Were you able to interview the defendant?
No, I was not.
Does the fact that you were unable to interview the defendant have an effect on your opinions?
While I would prefer to have the opportunity to speak with him, the materials I reviewed were sufficient for me to reach my opinions.
After reviewing all of the materials that were available to you, were you able to reach an opinion on whether Mr. Ray was suffering from a mental disorder at the time that he killed his son?
Yes, I was.
Do you hold that opinion to a reasonable degree of medical certainty?
I do.
What is your opinion?
In my opinion, there was no evidence that any mental disorder played a significant role in Mr. Ray's actions at or near the time he killed his son.
Dr. LaGreca, you're aware that the defense is claiming that the defendant was suffering from severe schizophrenia on the day he killed his son?
Yes, I read that in Major Riley's report. In my opinion, Mr. Ray was actually malingering, meaning he was either exaggerating his symptoms or not experiencing any symptoms at the time of Nathan's murder.
Dr. LaGreca, before we go any further, please explain to the jury what schizophrenia is.
Schizophrenia is a mental disorder suffered by less than 1% of the population. It causes a person to have a distorted perception of reality. They may have delusions, hallucinations, and disorganized thoughts or speech. People with schizophrenia may, in turn, withdraw from their relationships.
Is everyone with schizophrenia affected by it in the same way?
Absolutely not. There is a range in the severity of schizophrenia. Some people will experience symptoms to a much lesser degree than others. In other cases, symptoms can be so severe that a person's judgment can be completely impaired.
Your Honor, I'm holding an excerpt from the DSM, which has been pre-marked as Exhibit 17A for identification. This can be found on page 93 of the record. Dr. LaGreca, do you have a copy of Exhibit 17A for identification?
Yes.
Do you recognize it?
Yes.
What is it?
It's an excerpt from the DSM-5 that defines schizophrenia.
Is Exhibit 17A a fair and accurate depiction of the DSM's definition of schizophrenia that you used during your review of this case?
Yes.
Your Honor, prosecution moves Exhibit 17A into evidence.
Any objection on behalf of defense?
No, Your Honor.
All right, it will be admitted, and if you'd like to publish to the jury, you can do so.
Dr. LaGreca, how does a psychiatrist determine when somebody is suffering from schizophrenia?
By comparing the symptoms the person says they're experiencing with the criteria listed here under diagnosis. A person suffering from schizophrenia must experience at least 2 of these listed symptoms for at least 1 month.
Mr. Khan, can you highlight those listed symptoms for us? Dr. LaGreca, did the defendant say he was suffering from any symptoms?
Yes. During his 2019 interview with Major Riley for this case, the defendant claimed that he was hearing voices, experiencing delusions, and experiencing what are called negative symptoms. Based on my review of the case, the symptoms he claimed to have did not meet the criteria for a diagnosis of schizophrenia.
What do you mean?
Let me give you an example. Mr. A claimed that he heard voices saying that his wife was cheating on him. Major Riley describes these as auditory hallucinations, but this isn't what the DSM means by hallucinations. Auditory hallucinations are when people hear a voice outside themselves that they believe everyone else can hear. The voices Mr. Ray describes are like when we hear our own thoughts in our head. The voices Timothy Ray described are better characterized as anxious internal thoughts, not auditory hallucinations.
You also said the defendant reported delusions. Can you tell us what delusions are?
Delusions are false beliefs that a person firmly holds, despite the fact that they're not based in reality at all.
Based on your review of the record, was there any evidence that the defendant was delusional?
Well, there was evidence that Mr. Ray reported feeling paranoid about his wife having an affair and leaving him. Major Riley also mentions that the defendant accused his primary doctor of speaking to his wife behind his back.
In your opinion, does that amount to delusional thoughts?
No. Mr. Ray's wife was actually having an affair, and like I mentioned, delusions are false beliefs not based in reality. Mr. Ray may have had paranoid thoughts and anxiety, but that's different from having delusions.
You also said the defendant reported negative symptoms. What are those?
Negative symptoms are symptoms of diminished emotional expression that take away from a person's ability to function. Dr. Riley categorizes Mr. Ray's reported loss of concentration, changes in sleep patterns, or inability to manage emotions as examples of negative symptoms.
Is it your opinion that the defendant was not experiencing negative symptoms?
No, I believe that Mr. Ray may very well have been experiencing the things Dr. Riley described.
Doesn't that support a diagnosis of schizophrenia?
No. The negative symptoms associated with schizophrenia impair a person's ability to function in life. Mr. Ray shared custody of his son with his wife. He held a job and completed everyday tasks like taking his son to soccer practice. The trouble Mr. Ray was having was not surprising, given the fact that he'd recently discovered that his wife was having an affair.
Dr. LaGreca, I'd like to move on now to the second part of your opinion, that the defendant was malingering or faking his symptoms. How do you determine when somebody is faking mental health symptoms?
The DSM provides 4 factors that psychiatrists should consider when trying to determine whether someone is malingering. I identified 2 of them in this case.
How many factors does somebody have to meet in order for you to conclude that they are malingering?
When evaluating for malingering, we're not looking for a specific number of factors. The focus, rather, is on whether after evaluating these factors, the physician conducting the evaluation concludes that the person is likely making up their symptoms or exaggerating their severity.
What was the first factor you found in this case?
Whether the medical evaluation took place in a legal context.
Why is that important?
Because Mr. A was being evaluated after being charged with murdering his son. Studies show that 1 in every 5 people interviewed in the context of a criminal investigation are malingering. Given his charges, Mr. A had significant incentive to exaggerate symptoms and even fake them outright.
You said that there were 2 factors you found. What was the second factor you found?
Whether there were discrepancies between Mr. Ray's claimed symptoms and the objective observation of those symptoms.
How did that factor affect your opinion?
I reviewed information from 4 different doctor visits for Mr. Ray prior to his arrest and compared them to the information he reported to Major Riley in 2019. I found major inconsistencies between the symptoms he reported before and after his arrest.
What major inconsistencies did you find?
In the visits between 2010 and 2017, Mr. Ray reported anxiety, some trouble sleeping, and depression. He also reported that his wife believed he was having mood swings. Not once did he report any hallucinations. After his arrest in 2018, however, he claimed that he had actually had a history of hallucinations that went all the way back to childhood.
Why is that significant?
Because there's no independent information to support his claim. Mr. Ray's wife, father, and employer never saw any signs that Mr. Ray had been hearing voices or seeing things before he killed Nathan.
No further questions at this time, Your Honor.
Thank you. Any cross-examination on behalf of defense for this doctor?
Yes, Your Honor.
All right, proceed whenever you're ready.
Dr. LaGreca, your discipline teaches that family history of a mental illness can increase the risk of a mental illness in a patient.
Yes.
Anxiety disorder experienced as a young man can worsen to a more serious mental illness.
That depends on what mental illness we're speaking of.
It could worsen to a mental illness like schizophrenia.
That's not correct. Anxiety does not lead to schizophrenia.
You would agree with me, anxiety disorder is a common disorder in America.
Yes, that's correct.
1 in 5 Americans suffer from anxiety disorder.
That's a statistic that is not in my expert witness report.
You would agree with me that childhood trauma can make a person more likely to develop severe mental illness?
It makes a child more likely to suffer from mental illness. I can't say as to whether severe mental illness would be the case.
Mental illness not treated could worsen to a more severe mental illness.
Yes, that's correct.
Dr. LaGreca, your opinion believes that there's a lack of evidence in Mr. Ray showing symptoms consistent with schizophrenia.
That's correct.
I want to talk about the hallucinations. You are aware that Mr. Ray described hearing voices?
Yes, that's what he said he had heard.
He referred to these voices as they?
Yes.
You cannot definitively categorize what Mr. Ray experienced was in fact voices.
No.
Similarly, you cannot definitively categorize what Mr. Ray experienced was in fact thoughts.
I think based off of his symptoms that they're more consistent with anxious internal thoughts.
Dr. LaGreca, you did not personally conduct an investigation for your analysis.
Can you clarify as to what you mean by investigation?
You did not conduct any interviews for your opinion.
No.
You relied on the evidence that was provided to you.
That's correct.
You did not interview Detective Booth?
No.
Detective Booth was familiar with Mr. Ray prior to this case, correct?
That's correct.
You did not interview Officer Wentz?
No.
Officer Wentz was the arresting officer on the night of October 19th, 2018.
That's correct. I would like to clarify, though, that I did review all the case materials, including some of the reports and the written transcripts.
Now, Dr. LaGreca, you did not personally interview Jessica Ray?
No.
She's the wife of Mr. Ray?
That's correct.
They were married for 6 years?
That's correct.
You did not interview Abe Ray?
No.
And that's Mr. Ray's father?
That's correct.
You did not interview Naja Jacobs?
No.
He was the boss of Mr. Ray at his job?
No. All of these people were interviewed by Major Riley, and
I understand that, Dr. LaGreca. I'm just asking about what you did. You did not interview Mr. Jacobs.
No,
You did not interview Dr. Riley.
no,
And Dr. Riley completed a psychiatric evaluation on Mr. Ray.
that's correct.
You did not interview Dr. Di Giuseppe.
No,
Dr. Di Giuseppe was Mr. Ray's primary physician.
that's correct.
You did not interview Dr. Narasimham.
No,
And that doctor was the one who prescribed Mr. Ray's current medication.
yes.
I have nothing further at this time.
Any redirect on behalf of the prosecution?
Yes, Your Honor.
All right, go ahead and proceed when you're ready.
Referring you to Major Riley, how many times did Major Riley evaluate the defendant?
Twice. Once in 2010 and then again in 2019 for this case.
When did Dr. Riley diagnose Mr. Ray with schizophrenia?
During the 2019 interview with the defendant.
And when was the defendant arrested for the murder of Nathan Ray?
In October of 2018.
Thank you. No further questions, Your Honor. May this witness be excused?
Yes, subject to any recross. Is there any recross? I don't doubt there will
No
be.
recross, Your Honor.
I figured. All right. Yes, this witness may be excused. And anything further on behalf of the prosecution?
No, with that, Your Honor, the prosecution rests.
Okay. At this time, we can take a quick break, 5 minutes, or does anyone need any more time than that?
5 minutes works for us.
Okay, we'll do a soft 5 minutes in case also the jurors need some time to step away for a moment. So between 5 to 10 minutes, then we'll return. And once everyone's here, we'll start back up with the defense case in chief, if they should provide one. All right, see you guys in about 5 to 10 minutes. Take care. All right, I know it hasn't been 10 minutes yet, but let's see if we can have people start to filter back in. All right, we got juror May, excellent. All right, so we got our prosecution, we got our defense. Let's just make sure we've got our jurors and we've got a fly in the courtroom. So that may be entertaining. All right, let's see, make sure that we have our other jurors here. All right, thank you, perfect. Thank you, juror. I'm gonna probably mispronounce that, but Renitz. It's my best effort, my apologies. And just waiting to hear from Quinn and Feeney. So if you could either chat or pop on really quickly on the video, just so we know that you're here, and then we will go ahead and start back up.
Feeney is here.
Perfect. And I think I heard the other one. All right, so sounds like we are good to go. Are there any matters, preliminary matters, before we start the defense case in chief to bring up?
Your Honor, if
Yes,
we could
Your
have a
Honor.
time check, please. Oh,
I think I heard both of you say requesting for a time check, so absolutely. Let's start with the prosecution. Whoever the time check person is, if you could come off of muting your video and audio so that we could see you, and if we could get, I think there's two of you actually, if we could get a time check for the prosecution, please.
Yeah, the time check for the prosecution, you have 24:45 remaining.
Okay, and Mr. Levine, does that sound about right for the prosecution?
Yes, it does.
Perfect, excellent. Then let's do a time check for defense, please.
The defense has 37:12 remaining.
Okay, and Mr. Rashad Khan, does that sound correct for the defense?
That sounds correct.
Excellent, wonderful, all on the same page, no disagreements. Then other than that, is there any other preliminary matters that you'd like to handle before starting to move to defense case in chief? So hearing nothing, all right, defense, if you could call.
Honor.
Oh, sorry.
At this time, defense does have one motion we'd like to make, a motion for judgment of acquittal under Federal Rules of Evidence, or Federal Rules of Criminal Procedure, excuse me, 29A. May I be heard?
Absolutely, please.
Under Federal Rules of Evidence, Criminal Procedure 29A, due to the prosecution has to give forth enough evidence to give a sufficient facts for a reasonable jury or trier of fact to find them in this case of action, first-degree murder, beyond a reasonable doubt. The prosecution has failed to bring forth sufficient evidence enough to sustain a conviction, even when viewing the evidence in light most favorable to the non-moving party, being the prosecution. Specifically, the prosecution has failed to prove the final element that Mr. Ray killed with malice aforethought. No evidence has been brought forth today to show beyond a reasonable doubt Mr. Ray's intent or mens rea at the time of the incident. While the prosecution brought Exhibit 10 forward, arguing that it goes to show Mr. Ray's mens rea, it does not. This exhibit goes to show Mr. Ray's intent to get rid of a corpse, but that's not what's at stake here. It's about murdering his son. There's no evidence for a reasonable jury or a rational jury to establish beyond a reasonable doubt Mr. Ray's mens rea for first-degree murder. And for that reason, we request Your Honor grant a judgment of acquittal for the defendant. Thank you.
Thank you. A response on behalf of the prosecution.
Yes, Your Honor. Per the instructions you're going to read to the jury, malice aforethought means to act with callous and wanton disregard for human life. From Detective Booth's testimony alone, we heard the defendant admit himself that he strangled his son to death for spilling his juice, after he screamed at him for spilling his juice, after he beat his son with a belt, and after he made him do exhaustive exercises. That's sufficient evidence for callous and complete disregard for human life.
All right, is this submitted? Yes, submitted, okay. Assuming no further argument, then I appreciate your argument on behalf of defense, but given that the weight is viewed in light most favorable to the non-moving party, we're going to go ahead and proceed and let you go ahead and present your case, defense, and then take it to the jury. If you have another motion after your close of your case, feel free to bring it. Otherwise, we'll proceed. But if you could call your first witness, defense.
Yes, Your Honor. At this time, defense calls Officer Wentz to the stand.
All right, Officer Wentz, you've been constructively sworn in. Defense, whenever you're ready, please proceed.
Thank you, Your Honor. Will you please introduce yourself?
My name is Officer Wentz.
Officer Wentz, how are you involved in today's case?
I was the first officer to come in contact with the defendant in this case during a sobriety checkpoint.
Now, before we get to the events with your interaction with Mr. Ray, I want to talk a little bit more about you. How long have you been an officer?
I have been with the Skelton Police Department for the last 2 years.
What kind of responsibilities do you have as an officer?
Right now, most of what I do involves traffic stops and checkpoints, regular police work such as that.
What training did you complete to become an officer?
After I graduated from my schooling, I did go to the police academy where I went through typical training officers do in addition to crisis intervention training.
What is this crisis intervention training?
The crisis intervention training program is a program for officers to learn how to better understand and deal with perpetrators who may be struggling with mental health conditions and how to best handle those situations.
Officer Wentz, I want to talk to you about the day with your interaction with Mr. Ray. What day was this?
This would have been on October 19th, 2018.
Are you working that day?
Yes, I was. I was working a double shift that day.
What shifts were you responsible for on that day?
Typical in the morning was a normal shift patrolling the city. And then for my night shift, I was scheduled for the sobriety checkpoint that I had worked multiple times before.
How did you come into contact with Mr. Ray on that night?
As his car pulled up, I did the normal things that I would do when a car approaches the checkpoint. I walked over and signaled for him to roll his window down.
Please describe what you see when you see Mr. Ray roll down his window.
Upon approach, I noticed immediately that he was completely disheveled. His hair was very messed up. His eyes were glassy and there were stains all over his clothing. As he rolled down the window, I additionally noticed a very strong stench of overwhelming body odor, as if he had been in his car for days.
After evaluating his appearance, what do you do?
At this point, I asked for his license and registration.
Does Mr. Ray give you his license and registration?
After quite a bit of hesitation, he attempted not to give the items to me, originally denying that he had them, but he did eventually hand them over.
At this point, were there any signs of intoxication?
No, and that's part of what was so strange. There was no slurring of his speech or other signs of impairment, but he was, like I said, definitely acting odd.
When you have his license and registration, what do you do next?
Well, I was going to go back and run his license and plates myself, but after the way he was acting, I was very concerned, and so I had my partner run his information and plates.
Why did you not run the information?
Due to his weird behavior, I wanted to make sure to stay near Mr. Ray, as I had concerns of both officer safety as well as concerns of him trying to flee the scene.
Officer Wentz, when you returned to Mr. Ray's vehicle, what happened?
It was at this point that he started asking me some really strange questions about the CIA and claiming that he could hear sirens, just very off the wall questions.
Why did this stand out to you?
Well, I mean, moments ago, I was sitting there having a conversation with him about this being a normal, routine traffic stop. And when I returned, he seemed as if he had no idea that conversation had happened, just bringing up stuff about the CIA.
Objection, speculation as to he didn't know the conversation happened.
Response?
Your Honor, this is Officer Wentz's rational basis that she believed that Mr. Ray didn't understand or didn't realize who he was speaking with.
Prosecution, response to that, please.
The Officer Wentz can testify to her perception. However, Officer Wentz just testified that the defendant did not know that a conversation had occurred between them.
one last chance on behalf of defense, if you could clarify your response to the prosecution's response.
Your Honor, it was Officer Wentz's rationally based perception that Mr. Ray did not remember or understand the conversation earlier of identifying that Officer Wentz was an officer and not necessarily with the CIA.
All right, so so assuming we don't go any further down this line, because normally in a normal trial where the mental state isn't really at issue, especially the not guilty by reason of insanity, this would come in like a freight train. However, I think given the topic here, we have to tread carefully. So for now, we're going to go ahead and overrule the objection posed by prosecution, but listen in. If you think they go further and cross the line, feel free to renew or bring up another objection. So at this time, overruled, continue.
Officer Wentz, how did you respond to Mr. Ray's comments of you being a CIA?
At this point, I decided it would be best for me to reiterate to him what I had said moments before, that I was with Skeleton PD. And so I did show him my credentials to let him know I am a Skeleton PD officer.
After you had identified yourself, what did you do?
After this, I did ask him to step out of the vehicle.
Did Mr. Ray comply?
Yes, he did.
What was Mr. Ray's demeanor as he stepped out of the vehicle?
It was at this point that he began to move very slowly, almost in a zombie-like state, and muttering to himself about his son and jumping jacks.
Are you aware if Mr. Ray was talking to you?
That's the thing. I don't believe that he was. He seemed to me like he was either talking to himself or to no one at all.
How did you react to Mr. Ray?
I asked him for clarification at that point, but he didn't answer me. He instead looked up at me like he didn't even notice I was there, as if we hadn't been interacting for at least the previous 10 minutes. And then he started to do a jumping jack.
Are you aware of why he was doing jumping jacks?
I have no idea. I told him to stand still, but it seemed to me like he hadn't even heard me, which is why I had to pull out my gun and tell him to stop moving to gain control of the situation.
Did Mr. Ray comply?
No, he did not.
What did you do?
I really had to fight with him to get his arms down, and that is when I decided, for my safety as well as my partner's, I needed to cuff him and sit him down on the curb a few feet away from my patrol vehicle.
Officer Wentz, what, if any, significant findings did your partner come back with from searching Mr. Ray's license and registration?
It was at this point that we learned of the missing report filed the day before. Once I did find this information out, I immediately called Detective Booth, and we decided to bring Mr. Ray to the police station.
Thank you. I have nothing further.
All right, any cross-examination on behalf of the prosecution?
Yes, Your Honor.
Please proceed.
Officer Wentz, in order to become a police officer, you had to attend the police academy, right?
Yes, I did.
That's where you receive the training it takes to become a police officer.
Absolutely, in addition to my undergraduate education, yes.
That's where you received the crisis intervention training you mentioned on direct examination?
Yes, I did.
That mental health training was only about 40 hours long.
Yes, it was 40 hours.
It was designed to help you identify and deal with people who might be mentally ill?
Yes, it was.
Not to diagnose them?
No, that's not in my job description.
Or to treat them?
No.
And to be clear, you don't have the mental health training it takes to diagnose the defendant with any mental disorder?
Not to diagnose, no, but to be able to understand what I'm dealing with when I approach a scene, yes.
You were working a sobriety checkpoint the night the defendant was arrested?
I was.
When the defendant drove up, you approached his car?
I did.
And asked to see his license and registration?
Yes, this is very typical during a sobriety checkpoint.
According to you, the defendant was antsy?
Yes, he was very antsy.
And he was not happy.
No, he did not appear happy to me.
At first, he refused to give you his license and registration.
Yes, at first he tried to tell me he did not have that with him.
That's right. After that, but you could see that his wallet was right on the center console of the car.
Yes, since his window was down, I was able to see that in the vehicle.
And you pointed that out to him.
I did.
And that's when he handed you his license and registration?
Yes, he did.
After the defendant gave you his license, you looked in his car.
I did, briefly, as I was walking back to my vehicle, yes.
You could see 2 bottles of bleach?
I could, yes.
Black trash bags?
Yes.
And a shovel?
Yes.
You gave the defendant's license and registration to your partner?
I did.
And returned back to the defendant's vehicle?
Yes.
Because you didn't want to leave him alone?
Not at that time, no. I had a variety of concerns at that point.
In fact, you ordered him out of the vehicle?
At that point, yes.
Because you were suspicious of him?
Yes, he was acting absolutely crazy.
After the defendant followed your order, he eventually got out of the car?
He did.
After he got out of the car, you could hear him say, "I'm a good father. I didn't mean it."
Yes, and at that point, I had no idea what he was talking about.
After you handcuffed him, you heard the defendant say, "He's gone."
Yes, I did.
You said that you didn't have any idea who the defendant was talking about?
Not at that time, no.
But you had learned that the defendant's son was missing?
Yes, at that point, yes.
You saw a child's booster seat on the back seat of the defendant's car?
I did, yes, when I looked in the car.
Right next to the shovel?
Yes.
After Detective Booth arrived, you drove the defendant to the police station?
I did, yes.
During that drive, the defendant was crying?
Yeah, he was still pretty emotional at that point.
And you could hear the defendant say, quote, "I messed up."
Yes, I did hear him say that.
And you heard the defendant say, "I didn't mean to do it."
Yes, I did.
No further questions, Your Honor.
Any redirect on behalf of defense?
No, Your Honor, no redirect. I just asked that Officer Wentz be excused.
Yes, absolutely. All right, then defense, when you're ready, if you could call your next witness.
Defense calls Major Riley to the stand.
All right, Major Riley, you have been constructively sworn in. Defense, whenever you're ready, please proceed.
Please introduce yourself.
My name is Major Shane J. Riley.
Major Riley, why are you here?
I was retained by defense counsel to review Mr. Ray's case and form an opinion regarding whether and to what extent Mr. Ray suffered from any mental disorder that could affect his ability to discern right from wrong.
Did you form an opinion for today?
Yes, I did.
Before we get to that opinion, what makes you qualified to discuss mental disorders?
I currently have a private practice called Riley Forensic Psychiatry, and where I work extensively with patients with psychiatric disorders, as well as 20 years of clinical practice.
What education led you to owning your own private practice?
First, I received my degree in biology from the University of Notre Dame, and then I received my Doctor of Medicine degree from the Uniformed Services University, where I graduated 4th in my class.
What, if any, further education did you receive after medical school?
After graduating from medical school, I completed a general 4-year psychiatry residency at the National Capital Consortium Psychiatry Residency Program at the Walter Reed National Military Medical Center. Following my residency, I completed a 1-year fellowship in forensic psychiatry, also at Walter Reed.
What did you do after completing your education?
After graduating from my fellowship, I went into the Army, where I served as a psychiatrist in the 2nd Infantry Division for a few years.
I want to take a moment to thank you for your service, Dr. Riley.
You're welcome.
What did you do after serving?
After serving, I worked for Walter Reed for 9 years until I finally opened up my own practice.
What did you do at Walter Reed?
I was a managing clinical psychiatrist in the psychiatric inpatient unit for 5 years. And then after that, I became the deputy director of the Department of Behavioral Health for 4 years.
What, if any, publications do you have dealing with mental disorders?
I have published 15 papers that were peer reviewed in the field of forensic psychiatry, 2 of which are specific to schizophrenia.
What certifications do you have?
Since 2001, I've been board certified by the American Board of Psychiatry and Neurology.
How many times have you testified in court?
I have testified as an expert witness 25 times, and 18 of those were criminal cases.
Now focusing on this case, what evidence did you use to help you come to your opinion?
The evidence I used, in addition to my background, were all of the materials on the joint exhibit list, former treatment I had with Mr. Ray, a clinical interview with Mr. Ray, and additional interviews with Mr. Ray's boss, Mr. Ray's dad, and Mr. Ray's wife.
Was this sufficient facts and data to form an opinion?
Yes.
What methods and principles did you use to come to your opinion?
I used the DSM-5 along with my background and clinical training to analyze the symptoms manifested by Mr. Ray during his lifetime.
Is this method reliable in your field of study?
Yes, I followed all of the accepted and reliable best practices within the field of forensic psychiatry.
Is your opinion based on a reasonable degree of medical certainty?
Yes, it is.
Your Honor, I move to admit Dr. Riley as an expert in the field of psychiatry and schizophrenia.
Any objection on behalf of the prosecution?
No objections, Your Honor.
All right, the expert will be received as such. Go ahead and move forward when you're ready.
Major Riley, what is schizophrenia?
Schizophrenia is a neuropsychological disease, also known as a brain disorder.
How are you able to diagnose someone with this disorder?
The DSM-5 outlines the criteria needed to diagnose someone with schizophrenia.
What is the DSM's criteria for schizophrenia?
A person must have 2 or more of the following symptoms for at least 1 month. They have to have delusions, hallucinations, disorganized speech, grossly disorganized or catatonic behavior, or have negative symptoms.
You noted negative symptoms. What are those?
Negative symptoms could be something like diminished emotional expression or a depressed mood. And these are symptoms that prevent a person from engaging in certain behaviors or would impair a person's ability to function.
And you stated that someone needs to have 2 or more of these symptoms. Why is that?
Schizophrenia as a condition manifests itself on a spectrum. Not all patients with schizophrenia manifest the same symptoms or severity of symptoms. In addition, symptoms typically appear gradually and without treatment become worse over time.
So what causes schizophrenia?
Potential contributing factors to a person developing schizophrenia include things like family history and genetics, brain changes, chemical changes, childhood trauma, drug use, or complications during birth.
I'd like to talk about a few of those. First, childhood trauma. How does that play a role?
Childhood trauma increases the risk of an individual developing schizophrenia later in their life because the events that happen during childhood have an immense impact on the developing brain. And studies have shown that the younger a patient is when they begin to show signs and symptoms of schizophrenia, the worse their prognosis is over their lifetime.
In your research of this case, what childhood trauma did Timothy Ray experience?
Timothy Ray suffered childhood trauma based on my interview with his father, Abe Ray. Mr. Ray's mother was neglective and abusive, according to what I learned in that interview.
What examples did Abe Ray provide of Timothy's childhood trauma?
Abe Ray informs me that Timothy's mother would often refuse to feed Timothy and would also force him to take baths in ice cold water.
How long did Timothy Ray suffer from childhood trauma?
He suffered this trauma from his mother from birth until age 3. And at age 3, Timothy's mother abandoned their family.
So I'd like to move on to genetics. How does genetics affect the potential for schizophrenia?
When a person has a family history of mental illness, such as schizophrenia, it increases the likelihood that that person will develop a mental illness in their life.
What did your research find regarding Timothy's mother's mental condition?
Objection, Your Honor. At this time, we would like to renew our motion we made in pretrial.
Vince?
Yes, Your Honor. This evidence was used by Major Riley in forming her opinion, and the jury has a right to hear this information in order to fully understand her opinion and make a determination on the credibility of Major Riley's opinion.
Now, correct me if I'm wrong, is this the childhood upbringing, childhood trauma issue that we've been talking about earlier today?
Yes, Your Honor.
Okay. Based on that, prosecution, if you could go ahead and make your argument again as to why, now that we've heard the evidence from your expert and from Detective Booth and from Wentz, Officer Wentz, if you could lay out why you think that this particular portion of this doctor's opinion is inadmissible.
Yes, Your Honor. I believe his line of questioning was going into the fact that his mother was suffering from a mental illness. On the record, there's no evidence that the defendant's mother had ever been diagnosed with a mental illness. The only evidence we have regarding this is the father discussing how the mother was institutionalized over 15 years ago. And we don't even know how many layers of hearsay the defendant's father had to go through to find out that his wife was institutionalized, or whether she was even institutionalized in a mental hospital or a prison.
Defense prosecution does raise a decent point when it comes to, we're not quite sure where this individual who relayed this information to the expert, how they got it, the veracity. If you could address that when it comes to the admissibility of this evidence otherwise, and whether or not that should come before the jury.
Yes, Your Honor. Major Riley did use this evidence in forming her opinion. And the question of credibility is a question for the jury, not this court. And the defense has the opportunity to cross-examine Major Riley and get her opinion on exactly the issues that they're raising here. But as I stated, credibility is a question for the jury and not this court.
All right. So as I understand your position, prosecution, what I'm going to do, this is how I'm going to rule. I'm going to allow it to come in. However, depending on how it's argued, given that what defense is saying, that they're only using it for the credibility of this expert witness's opinion, and that whether or not that opinion is sound, and for the fact finder to go ahead and make that determination, depending how that's used in closing argument, listen very carefully if they start arguing it for the truth, or if they start arguing it to use, I don't know, sympathy, compassion, something beyond the pale of just for this expert's credibility. So I'm going to go ahead and overrule the objection, but keep it in mind. And whenever you're ready, defense, please proceed.
Major Riley, how about related mental illness? How does related mental illness contribute to schizophrenia?
Many patients with schizophrenia also suffer from things like anxiety disorder, depression, or have thoughts of suicidal ideation.
What did you notice from Mr. Ray regarding related mental illness?
Mr. Ray did experience all three of the related illnesses I just noted in his history. Even back while he was serving in the Army, Mr. Ray suffered from anxiety disorder and depression when I saw him in 2010.
You knew Mr. Ray prior to this case?
Yes, I performed a full psychiatric evaluation at the Walter Reed Inpatient Adult Psychiatric Unit in 2010.
What symptoms did you observe in 2010?
I observed symptoms of anxiety and depression.
What were your findings?
I diagnosed Mr. Ray with generalized anxiety disorder at that time.
What other symptoms were reported at that time?
Mr. Ray's commanding officer reported that Timothy was suffering from hallucinations and suicidal ideations.
Why didn't you include these in your diagnosis?
I can only diagnose a patient based on the symptoms that I myself observe or symptoms expressed to me by the patient.
In your research of this case, why might Timothy Ray not express these symptoms to you?
In my later interview with Mr. Ray, he stated that he feared telling anyone about his symptoms because he was afraid of being labeled crazy like his mom.
Out of the 5 symptoms of schizophrenia, how many symptoms did Mr. Ray exhibit in your analysis?
Mr. Ray exhibited 3 of the 5 symptoms of schizophrenia.
Which symptoms did he demonstrate?
Mr. Ray had delusions, hallucinations, and negative symptoms.
What delusions was Mr. Ray showing?
Mr. Ray showed signs of delusions through his paranoia regarding his wife and son in the years leading up to October 2018. Mr. Ray expressed these concerns when he met with Dr. DiGiuseppe in 2017, also on October 17th, 2018, and in his later interactions with Officer Wentz. Mr. Ray also expressed such paranoia during our clinical interview.
And let's break that down. What paranoia did Timothy express to Dr. DiGiuseppe?
Mr. Ray thought that Dr. DiGiuseppe was conspiring with his wife, Jessica, behind his back.
And what were your conclusions on the validity of these paranoid thoughts?
They were not true.
What paranoia did Timothy express on October 17th, 2018?
Mr. Ray thought that his wife, Jessica, told their son to intentionally spill juice on his laptop in order to sabotage him.
And what were your conclusions on the validity of these paranoid thoughts?
They were not true.
What paranoid thoughts did Timothy express during his interactions with Officer Wentz?
Mr. Ray repeatedly asked Officer Wentz if he was with the CIA.
And what were your conclusions on the validity of thoughts?
They were not true.
What paranoia did Timothy express in your clinical interview?
Mr. Ray accused me of being a government agent and thought there was a camera in the microwave of my office. He was also paranoid that his wife and son would cut him up with a knife and leave him.
And what were your conclusions on the validity of these paranoid thoughts?
They were not true.
What about hallucinations? What hallucinations did Mr. Ray exhibit?
Mr. Ray reported auditory hallucinations beginning when he was 10 years old and visual hallucinations as early as 2010 when he was discharged from the Army. While these symptoms were intermittent, I noticed that Mr. Ray had sporadic visual and auditory hallucinations in 2017 and also in October of 2018.
How did Timothy describe the visual hallucinations leading up to October 2018?
Mr. Ray described them as triangles on the wall, which changed shapes and colors.
How did Timothy describe the auditory hallucinations leading up to October 2018?
He reported hearing male voices, which would randomly pop up and tell him to hurt other people.
How did Timothy describe the auditory hallucinations on the day of October 17th, 2018?
He reported hearing a creepy voice that told him to kill his son for acting out and that his son sabotaged his laptop on purpose.
Finally, what negative symptoms did Mr. Ray show?
It was clear to me that Mr. Ray suffered from negative symptoms when he demonstrated angry outbursts during our interview and had episodes of crying. I also learned that Mr. Ray had a social phobia related to locking himself in the bathroom, and he had always had issues with mood swings. In addition, Mr. Ray has been constantly seen to be in a disgruntled or a disheveled look, as though he had not showered in a few weeks.
Who all witnessed these negative symptoms?
These negative symptoms were witnessed by Mr. Ray's wife, coworkers, Detective Booth, Officer Wentz, and me.
Has Mr. Ray ever been formally diagnosed with schizophrenia?
No, he has never formally been diagnosed, but I do believe Mr. Ray was suffering from symptoms consistent with severe schizophrenia as of October 17th, 2018.
Why did you not formally diagnose Timothy Ray in your clinical interview?
My job was to form an opinion on Mr. Ray's mental state. My job was not to formally diagnose him.
What medications is Mr. Ray taking?
Currently, Mr. Ray is prescribed 300 milligrams of Seroquel.
Your Honor, defense would like to make judicial notice of stipulation number 7.
And so our jurors know, what stipulation is that?
Yeah, stipulation 7 is that Seroquel is an antipsychotic used to treat certain mental conditions and mood conditions. Seroquel can be used to treat schizophrenia, bipolar disorder, sudden episodes of mania or depression associated with bipolar disorder.
All right, and understanding that this was stipulated to, I'm assuming there's no objection on behalf of the prosecution, correct?
No objection, Your Honor.
All right, received, and move on when you're ready.
Major Riley, what is Seroquel generally used for?
Seroquel is used to treat schizophrenia, bipolar disorder, or sudden episodes of mania or depression.
Dr. Riley, why is it important to identify if someone is suffering from severe mental illness, such as schizophrenia?
Mental illness, like schizophrenia, can impair a person's ability to understand the nature of their actions. Simply stated, a person who suffers from schizophrenia might not be able to understand right from wrong in their actions.
Thank you. I have no further questions.
Cross-examination of Major or Dr. Riley, whenever you're ready.
Good afternoon, Major Riley. You're a military forensic psychiatrist.
Yes,
Major, your practice provides services to veterans who are parties in legal matters.
That's correct.
Like the defendant.
Yes.
But the defendant's status as a veteran isn't your only connection to him.
No, it's not.
He's a former patient of yours.
Yes, he is.
And that's one of the reasons why you decided to charge him less than your normal hourly rate.
Given his military background and my former treatment, it was less time consuming and it took less effort for me to review all of his files. So I did charge a lower hourly rate.
And you actually also reduced your fee to review his case, right?
Yes, I think that's what I just said.
You hope that a favorable outcome in this case will provide awareness to the mental health burdens veterans carry.
I think a favorable outcome in any case involving mental health will be a positive impact on anybody who suffers from mental illness.
Now, you first met the defendant in 2010.
Yes, that's correct.
That's when you evaluated him for the first time.
Yes.
He just completed his basic training. Is that a yes?
I'm sorry, is there a question?
He just completed his basic training.
Yes, he had.
But he'd been discharged shortly before you saw him. Is that a yes?
Yes.
Now, you performed a full psychiatric evaluation of the defendant at the time.
Yes, I did.
But he specifically denied having any hallucinations.
As I stated earlier, he told me that he denied those symptoms because he was scared of being labeled as crazy.
So the answer to my question is yes?
Yes, he did.
But your opinion today is that the defendant was suffering from visual hallucinations back in 2010?
Yes, after receiving all of and reviewing the rest of the interviews and the clinical judgment, yes, I do believe that's true.
But nonetheless, in 2010, you diagnosed the defendant with general anxiety disorder.
As I just said, I have more information available to me now, but with the information I had in 2010, yes, I believed he was suffering from generalized anxiety disorder.
And in 2010, you did not diagnose him with schizophrenia.
No, I did not.
Now, you also evaluated the defendant in 2019.
That's correct.
1 year after he'd admitted to strangling his son to death.
Yes, that's correct.
And this time, you were paid an expert consulting fee for your work. Is that a yes?
Yes.
And during this evaluation, the defendant claimed that he'd been hearing voices since he was 10 years old.
Yes.
Now, you interviewed the defendant's father as part of your work in this case. Is that a yes?
Yes.
And he never said anything to you about the defendant hearing voices growing up, right?
Not that I recall.
You also interviewed the defendant's wife, Jessica Ray.
Yes, I did.
She never said anything about the defendant having hallucinations.
She reported mood swings, but didn't specifically say hallucinations.
You also interviewed the defendant's boss at work.
Yes, I did.
He never said anything about the defendant hallucinating either.
No, I don't believe there was any report of that.
Now, as part of your preparation, you reviewed notes from when the defendant visited a doctor in jail.
Yes, I did.
That visit was 1 month after your 2019 interview with the defendant.
Yes.
Mr. Ray actually asked for that interview. Is that a yes?
Yes.
He told that doctor he was feeling depressed. Is that a yes?
Yes.
Anxious.
I'm sorry, is there a question here for me to answer?
Yes, I'm cross-examining you. These are all questions. I would prefer a verbal answer, please, for the record.
Okay, can you repeat your question, please?
He told that doctor he was feeling anxious.
Yes, he did.
And in a constant state of worry.
Yes.
Now, we can admit that those feelings aren't surprising for somebody facing a murder charge, right?
Right.
But there is no indication that he told that doctor that he was hearing voices.
Not in the written report.
Or seeing things.
Again, that wasn't written in the report, no.
There's no indication in that report that he told that doctor he was having any hallucinations.
Like we stated earlier, the symptoms can be intermittent, but at that time that he saw the doctor, he did not report seeing or hearing things that weren't there.
Now, that doctor prescribed the defendant Seroquel.
Yes.
Which can be used to treat schizophrenia.
Yes, it can.
But it can also be used to treat other mental conditions.
Yes, it can.
Like bipolar disorder.
Yes, that's correct.
Or mania and depression associated with bipolar disorder.
Yes.
But the jail doctor's notes indicate that they did not make any formal diagnosis of Mr. Ray at the time.
Yes, that's correct.
Now, you also believe that the defendant was suffering from delusions leading up to the time he killed Nathan.
Yes, that's correct.
You say his paranoia about his wife having an affair constitutes a delusion.
Yes, it did.
But Miss Ray actually admitted to you that she was having an affair, right?
At a later time, yes.
And you read in Dr. DiGiuseppe's testimony that the defendant's wife was threatening to leave her as far back as 2014.
Yes, I believe they had marital issues from a new baby at that time.
You also believe the defendant was exhibiting extreme paranoia on the night he was stopped at the sobriety checkpoint.
Yes, that's correct.
Because he claimed the CIA was following him.
Yes, he did.
Now, you admit that there is a much higher likelihood of faking symptoms when facing a murder charge.
I don't recall about having a much higher likelihood.
Major Riley, you remember testifying as an expert witness in State v. Dominisk?
Yes, I do.
And you gave an oath before you testified.
Yes, I did.
And you swore to tell the truth.
Yes.
And you did tell the truth?
Yes, I did.
Referring court and counsel to page 91, lines 14 through 17. Major Riley, during that court case, when you testified, you said, generally, the more serious the crime and the more serious the punishment, the higher there is the likelihood of malingering or faking symptoms. For example, a murder charge is the most serious crime one can commit, and it carries the most serious penalties. In a situation like that, there is a much higher likelihood of malingering.
Okay.
So you admit that there is a much higher likelihood of faking symptoms when facing a murder charge.
Yes, that's correct.
And the defendant had killed his son just 2 days before he told the police he was being followed by the CIA.
Yes.
Thank you. No further questions, Your Honor.
Any redirect on behalf of defense?
No, Your Honor. At this time, the defense rests its case in chief.
Okay. Then does everyone need a brief moment before we move to closing arguments? I guess the advocates need a brief moment. All right, let's go ahead and take a 5-minute break. And once we get back, we'll start up. And if there's any preliminary matters to address, let's address it when we come back from the break. Okay? All right, see everyone in about 5 minutes. All right, that was about 5 minutes. And let's, looks like we got most of the advocates in. Let's make sure that most important people in the room, the juror, there we go, Juror May, thank you very much. And I think we've got a couple more, so either in chat, whoever. All right, good, got another one. So there's 2 more. Juror Reynolds is here, and again, I apologize if I mispronounced that, and just waiting on 2 more jurors.
You stopped your Quinn's video. You'll need to restart it, but I'm here.
Not exactly sure who that was, but if that was a juror trying to let me know that you were here, if you could just restate that. We're just waiting on 2 more jurors.
Feeney's here. I'm here.
And is here.
All right, perfect. Sounds like we got everyone. Excellent. All right, now, assuming we got everyone else, it looks like we do. Whenever, is there any preliminary matters that we need to handle before moving to closing arguments? Right, looks like nothing. Excellent. Prosecution, whenever you're ready for your closing arguments, please proceed.
About 2 years ago, this past Monday, Jessica Ray found out the worst news a mother could ever find out. Like my co-counsel told you in our opening statement, we have the responsibility to prove that the defendant murdered his 6-year-old son, Nathan. We also promised you that the defense would fail to meet their burden of proving that the defendant suffered from a mental disorder that excuses him from being responsible for his son's death. The evidence has done this by establishing 2 things. First, the defendant knowingly killed his son by strangling him to death. And second, that the defendant understood that killing his son was wrong. Let's start by taking a look at the first point, that the defendant knowingly killed his son by strangling him to death. Like Judge Saucedo instructed you, in order to find the defendant guilty of murder, we have to prove that he killed his son with malice aforethought. Now, that doesn't mean we have to prove he hated or had any ill will towards the boy. Malice aforethought means killing in a way that's callous, cruel, and with a complete disregard for human life. And members of the jury, a father using a belt to strangle his 6-year-old son with, that's about as callous and cruel as it gets. In order to understand why the defendant chose to end the life he helped create, we only need to look back to the moments right before the killing. Nathan was getting ready for school that morning, just like millions of kids across the country. He was in the kitchen eating his favorite cereal and drinking apple juice when he accidentally spilled the juice on his father's work laptop. Instead of understanding that dealing with spilled juice is just part of being a parent, the defendant started yelling and screaming at the 6-year-old boy. Nathan started crying, saying he wanted his mother, but that just made the defendant yell even more. Nathan ran upstairs to his bedroom, his safe place, but the defendant followed. More yelling, more screaming, more of Nathan sobbing for his mother. And that had to be hard for the defendant. You see, it had only been a few months since he was able to confirm that his wife was cheating on him, something he'd suspected for years, and now they were separated. So hearing his son cry for her, well, that's just unacceptable. So he forced Nathan to do exercises, jumping jacks, running in place, high knees, anything to get the boy to stop crying for his mother. But that just made Nathan cry even harder. So the defendant decided he was going to beat the tears out of him. He went into his room and he grabbed a belt and started spanking the 6-year-old boy. And when that didn't work, he took the belt and he wrapped it around the little boy's neck. And he squeezed the screams and life out of him. And I want you to really think about what strangulation takes. It's not a quick death. It takes time. We've all held our breath to see how long we could do it, right? 5, 10, 20, 30 seconds. However long Nathan could hold his breath, the defendant had to squeeze longer than that. He squeezed and squeezed and squeezed until he made sure his son would never be calling out for his mother ever again. Now, those facts are really undisputed. They came from the defendant's own mouth. It's what he admits took place. And as hard as it is for us to accept, some parents make the decision to kill their children just like the defendant did. And everything he's done since then has shown that his decision, that he was fully aware that his decision to kill his son was just unforgivable. And that brings me to my second point, that the defendant understood that killing his son was wrong. Since we know there's no reasonable doubt that the defendant is guilty of murder, the only other things left for you to decide is whether the defense has proven that the defendant suffered from a severe mental disease or disorder when he killed Nathan, and if so, whether they've proven that the mental disorder kept him from understanding what he was doing or kept him from understanding that it was wrong. Now, the defense claims that they've proven the defendant was suffering from severe schizophrenia on the morning he killed Nathan. He'd never been diagnosed with schizophrenia up to that point, even though he had been evaluated by a psychiatrist. In the military, he was hospitalized and discharged due to general anxiety and depression, but no sign of the schizophrenia they claim has been developing since he was a young child. And members of the jury, as bad as the defendant's breakup with his wife had been, did you hear any evidence that she saw signs that the man she married, lived with, and shared a family with was suffering from a severe mental disorder? Sure, she asked him to see someone for his anxiety, but had there even been the slightest hint that he was severely mentally ill, that he was the slightest threat to Nathan's safety, wouldn't she have seen it? Wouldn't the defense have brought you some evidence that shows that she saw him as a risk and she fought to keep her son away from the defendant? They didn't bring that evidence because it just doesn't exist. So where does the schizophrenia diagnosis come from? Well, Dr. Mac LaGreca, the expert forensic psychiatrist we brought you in this trial, explained it to you. The defendant is malingering or faking his symptoms, to put it simply. And why would someone do that? Well, in order to avoid facing things such as prison time. So let's take a look at how Dr. LaGreca reached that conclusion. The defendant is being evaluated in the context of a criminal case, which is one of the factors that psychiatrists should look for when determining whether somebody is malingering. And like Dr. LaGreca told you, 20% of people being evaluated in this context are being diagnosed as malingering. And the defendant isn't on trial for just any criminal case. No, he's on trial for murder of his son with no other evidence to even suggest anybody else could have done it. This context alone should give you reason to doubt the defense's claims. But that's not the only thing that shows the defendant is malingering, because his claimed symptoms just don't match with the rest of the evidence. The defendant claimed he'd been hearing voices since he was 10 years old and seeing things since he was in his early 20s. But the defendant never mentioned hearing voices until 1 year after he killed his son. And he specifically denied having any visual hallucinations when he saw Dr. Riley in 2010. And although his behavior with his personal doctor, Dr. Samantha DiGiuseppe, may have been bizarre, if he was dangerous, wouldn't she have done more? Especially if he was dangerous and refusing to seek treatment? And as for Officer Wentz's testimony, that the defendant appeared to be acting odd at the checkpoint, well, it's not hard to believe that somebody about to be arrested for murdering their child would pretend they were mentally ill. Members of the jury, that's everything you need to conclude that the defense has failed to prove that the defendant was suffering from schizophrenia. But let's give the defendant every benefit of the doubt for just a minute and assume they did establish he was schizophrenic. that's still not enough. Like the judge told you, even if they establish he was schizophrenic, they still have to show that he was not able to understand what he was doing, or he was not able to understand that it was wrong. An example of this would be like if he strangled his son but thought he was fastening a seatbelt around the boy's waist. Or if he truly believed that by strangling his son, it would somehow make Nathan healthier. But there's no doubt that the defendant knew exactly what he was doing. Remember these internet searches? Why would the defendant look for ways to get rid of Nathan's body if he didn't understand that killing him was wrong? And what about the search for countries that don't extradite for murder? Members of the jury, that not only shows the defendant was thinking about fleeing the country, it shows that he knew he'd committed murder. And well, clearly, he learned something from those searches, because the night he was arrested, he was found with gallon bottles of bleach, just like he searched for on the internet. And as for his search about how to get rid of a body, well, we know he came up with a plan there, when he tossed his boy's body in a shallow grave in Brandywine Park. Now, in a moment, the defense is going to have a chance to talk to you. And when they do, I want you to ask yourselves if it makes sense. When they look you in the eye and tell you that they have proven that the defendant isn't legally responsible for murdering the one person he was supposed to love and protect. And when those explanations don't make sense, when they leave you with more questions than answers, then you'll know the only just verdict is one finding the defendant guilty of murder.
Thank you. All right, defense, whenever you're ready, your closing argument.
Yes, Your Honor. May it please the court, Your Honor, opposing counsel, members of the jury, you cannot stop what you cannot control. At the beginning of trial, my co-counsel, Mr. Hodak, explained to us who the defendant was and how Mr. Ray could not stop what he could not control. He could not stop his past trauma that he grew up with. He could not stop suffering from a mental illness, and he could not stop the voices he heard on October 17, 2018. Now, today's case focuses on a very real problem: mental illness. Mental illness is something that should be talked about more openly. Why? Dr. LaGreca, prosecution's own witness, told us because nearly 1 in 5 Americans suffer from some sort of anxiety disorder. That's scary. Now, before we get into the facts of today's case, I want to remind you all what you are deciding. As the jury, you're deciding whether Mr. Ray committed first-degree murder. And this charge has a heavy burden. It is the highest burden in a criminal trial, and that burden rests on the prosecution. Prosecution had to prove to you every element of the case beyond a reasonable doubt. Now, beyond a reasonable doubt means a doubt that would cause a reasonable person to pause or hesitate when making an important decision in his or her own life. Think of the burden like a brick wall. Every piece of evidence you heard is a brick that builds that wall. And to meet their burden, the prosecution had to knock down that wall. They had to meet their burden for every single element. First, that there was a death. And that's not contested today. Tragically, Mr. Ray lost his son on October 17, 2018. The second element is that the death was caused by the defendant. And third, that there was malice aforethought. Now, this legal jargon may be confusing, but you are answering a simple question. Did Mr. Ray act willfully, deliberately, or intentionally in order to kill his son? After all the facts and evidence that came in at trial today, we see that the prosecution failed to meet their burden, to knock over that wall. Members of the jury, if that brick wall is still standing, you must find Mr. Ray not guilty. Now let's discuss the bricks that are still standing. What the prosecution failed to prove was malice aforethought. Did Mr. Ray decide to kill his son? prosecution has failed to prove that Mr. Ray decided to kill his son, that in the moment of the accident, Mr. Ray meant to kill his son. We heard what happened that day. Mr. Ray was getting his son ready for school, and unlike when he was a child, Mr. Ray made sure his son had a meal that morning. As his son finished his cereal and was finishing his juice, Mr. Ray was getting his work things in order. While his laptop was on the table getting ready to go, things turned sour as his son spills juice on his laptop. Now, before he could react, a voice tells Mr. Ray that he has to punish his son because his son did it intentionally. His son was trying to sabotage him. When he had to remember the horrible events that occurred on October 17th, he told the detective, "I didn't mean to." These voices that Mr. Ray hears pushing him to punish his son, that he needs to make his son understand, this is when tragedy occurred, as Mr. Ray could not stop what he could not control. From all the testimony we heard today, what did we not hear? That Mr. Ray decided to kill his son, that Mr. Ray intentionally killed his son, that Mr. Ray willfully killed his son. Members of the jury, this was not a malicious murder. This was a parent suffering from a mental illness he could not control that caused him to lose his son. However, in the end, if you find the prosecution has met their burden, the defense has brought sufficient evidence to prove an insanity defense. To meet our burden, we have to show through clear and convincing evidence 2 elements. First, that Mr. Ray suffered from a severe mental illness. And second, that severe mental illness made Mr. Ray unable to appreciate his actions. Clear and convincing evidence is a much lower burden than beyond a reasonable doubt. Unlike the prosecution, we do not need to push down that brick wall. Rather, we simply have to show that it was highly probable that Mr. Ray suffered from a mental illness that made him not able to understand his actions on October 17, 2018. Through clear and convincing evidence, we, the defense, have proven that Mr. Ray's actions were the result of a severe mental illness, and that Mr. Ray could not control his actions. Second, that the mental illness Mr. Ray was suffering made him unable to understand what he was really doing. Members of the jury, we heard from 2 expert witnesses, Dr. LaGreca and Dr. Riley, who both identified that mental illness at a young age can worsen as time progresses. Untreated mental illness can worsen. In addition, we learned that Mr. Ray was predisposed to having a severe mental illness through past diagnosis and trauma. While Mr. Ray could not control how people labeled his mother, he could control what he thought, what people thought of him. And Mr. Ray did not want to be labeled crazy. He tried to control people's perceptions of him and tried to hide his suffering. While he attempted to hide his suffering, Mr. Ray ultimately could not hide. In 2009, after joining the Army, before he could serve his country, Mr. Ray was discharged from the Army. And it was at this time that he was formally diagnosed with general anxiety disorder by Dr. Riley. Second, a major risk of mental illness deals with trauma, specifically childhood trauma. Dr. Riley and Dr. LaGreca told us childhood trauma can make a person more likely to develop severe mental illness. Mr. Ray could not control the abuse and neglect he received from his own mother. Until he was 3 years old, Mr. Ray inconsistently was fed, was bathed in ice cold water, and in the end abandoned by his own mother. Mr. Ray's experiences was not a common one. It was filled with major childhood trauma that he could not control, which led Mr. Ray to have an increased risk of suffering from a severe mental illness. While Mr. Ray was never formally diagnosed with schizophrenia, the defense has brought ample evidence to show that Mr. Ray was suffering a severe mental illness that could be consistent with schizophrenia. To be diagnosed with schizophrenia, a patient must show 2 or more factors listed on the DSM-5. And after hearing all the evidence today, we see that building up to October 17, 2018, Mr. Ray had shown symptoms consistent with 3 of the 5 factors: hallucination, delusions, and negative symptoms. We can see the progression of Mr. Ray's suffering from Dr. Riley's testimony. Since he was 10 years old, Mr. Ray suffered from auditory hallucinations, or what he labeled voices. While they haven't been identified, he always referred to them as they. Even during his interview with Detective Booth, Mr. Ray identified these voices that told him his wife tricked their son, told him that his son did it on purpose and was trying to sabotage him. And in the end, they were the voices that told him he needed to make his son understand. Members of the jury, does this sound like a man who's thinking clearly? Or does this sound like a man suffering from a mental disorder he could not control from the beginning? We learned about the delusions Mr. Ray suffered, the paranoid statements he made where he thought the CIA was after him, that the CIA sirens were coming to get him. Mr. Ray's paranoia was visible when he was interviewed by Dr. Riley. And Mr. Ray thought there was a camera in Dr. Riley's microwave. When Mr. Ray visited Dr. DiGiuseppe, Mr. Ray was worried that Dr. DiGiuseppe was speaking with his wife without his knowledge. Dr. Riley identified examples of delusions due to the comments that Mr. Ray made. And based on her diagnosis, Dr. Riley found no truth to any of the paranoid statements Mr. Ray made. And finally, negative symptoms. He showed negative symptoms through lack of hygiene. When he took his son to soccer practice, other parents noticed how Mr. Ray was disheveled, hair messy, and had a strong reek of body odor. This does not change when Mr. Ray was arrested on October 19, 2018. Right away, Officer Wentz noticed that Mr. Ray was disheveled, messy, and had a strong, overwhelming body odor. Members of the jury, while Mr. Ray was never formally diagnosed with schizophrenia, he is currently prescribed medication to treat mental and mood disorders consistent with schizophrenia, bipolar disorder, and mania depression. As we look through Mr. Ray's history, we saw that he met 3 of the 5 factors consistent with schizophrenia. He suffered a mental illness leading up to October 17th. And it's important because we learned how people who experience severe symptoms of mental illness, like schizophrenia, well, that could impair their ability to understand the nature of their actions. This includes the ability to understand right from wrong. As we look at the totality of the evidence, we see that Mr. Ray could not stop what he could not control. Could not control the abuse and neglect he received as a child. He could not control himself from being diagnosed with general anxiety disorder. He could not control the voices he heard on October 17, 2018. In the end, we see that Mr. Ray could not stop nor control his suffering, which led to the unfortunate events leading us here today. And because of that, we ask that you find the defendant, Mr. Ray, not guilty of first-degree murder, because he's not.
Any rebuttal on behalf of the prosecution?
Yes, Your Honor.
Proceed whenever you're ready.
Members of the jury, the defense just spent over 11 minutes talking to you about anything and everything but what happened the day Nathan died. Now, as complicated as they want this all to seem, here's all you need to know. If the defendant was insane, he wouldn't have searched for this after using this to kill him. If the defendant didn't know his actions were wrong, he wouldn't have used these to do this with Nathan's body. He would have just left the body sitting in the house. The only person who was in a lack of control was Nathan Ray. The defendant knew right from wrong when he yelled at his son for spilling the juice. He knew right from wrong when he hit his son and when he looked up how to get rid of a body and when he dug a shallow grave and tossed the boy's body inside for dogs to find. And because of that, justice demands the defendant be found guilty of murder.
Thank you very much. Thank you, everyone. Congrats on being finished. Before we get to comments, though, I'm instructed to make sure that the jurors complete their ballots and return them. If you want me to tell you how to do that, I don't have the answer to that. So hopefully you have the instructions for that. So in the meantime, the advocates, if you guys could wait around, obviously mute yourselves and the video. And then once we get confirmation that the ballots have been turned in, then we'll come back for brief comments from each of the jurors, and then you guys can go on your merry way. All right, so I'm gonna go ahead and go on mute and wait for the jurors to finish up their ballots. And then once we get the okay, we'll start back up. Thanks. All right. We've been given the clear that all of the ballots have been turned in. So as the advocates come in, now we have our comments. I have literal instructions to keep them brief. So I have a whole script that I'm supposed to follow. I'll be very brief. Just so you know, my background, prosecutor, so you know where I'm coming from. Y'all did very well. I'm not gonna even get into specifics. Just keep up the energy. Good luck for your next round. Other than that, great job. I'll leave it to the jurors to give you more specific comments.
My name's Melissa May. I'm a judge on the Indiana Court of Appeal, and I also teach trial practice at McKinney in Indianapolis. And we were also instructed to keep it short. So very good job. The level of preparation that I saw from all of you was excellent. I thought that you handled responses to objections well. And I thought that you also did pretty good jobs with hard witnesses, and experts on cross are extraordinarily difficult. So thumbs up, really good job. Good luck in the competition.
Whoever wants to jump in next as a juror for comments.
I will go. I'm Amanda Reinitz. I'm an assistant U.S. attorney here in Philadelphia in the criminal division. I echo Juror May. Great job to everyone. The only feedback that I would give is, I know that this is a mock setting, so you're trying to show that you know the rules, but be careful how many objections you're making. Sometimes you're objecting to things that you know have to come in, or it's just not going to be fair to both sides, and you can kind of use up a lot of time with an objection that ultimately is going to be pointless. So it's usually a better strategy to save your big objections for things that you might have a better shot of coming through with a win on. But great job. Good luck to everyone.
All right, I think that leaves us with two more jurors. If you have comments, just activate your video, because we have it in a way where, at least for me, I can only see those who have, there we go.
Okay, I'm here. All right. Everybody did a fantastic job. My name's Robin Feeney. I do personal injury in Philadelphia, so I do all civil trial work. Criminal's never been my thing, but I think really fantastic job. This, if I have one thing to say, if you're going to make the argument that the prejudicial value is outweighed by the probative effect, you got to tell us why. It's just not because we feel it. Okay, like any judge is going to say, but you know, and so that's just something that I came away with. Like, if you're going to make that objection, you have to say this is why. But really, you did a great job, all of you. Terrific preparation, and I actually enjoyed it. My first time ever, and I did. So good luck, all of you.
All right, I think that leaves us with Juror Quinn.
Yes. Okay, well, congratulations to all of you. You can't see me because the judge has blocked me. But I've been doing these mock trial judging juror for a number of years. I'm going to give you the same advice I give all of them at, you know, the high school, to college, law school levels. And that is, always have a plan B, because practicing law in Philadelphia for 43 years, I'm not convinced the judges always know the rules, and they rarely know your case before picking up a file and being handed it and calling you for trial at a start at 9 o'clock tomorrow morning. So always have a plan B, because you never know how the objections are going to go. You never know how the preliminary motions in limine are going to go. So have a plan B to get ready to get your evidence in one way or another. So congratulations. I think all of you did an excellent job. Thank you.
All right, so that concludes the first round. Again, congrats, guys. Got your first round under your belt. 2 more to go. Hopefully more for everyone else tomorrow and Sunday if you advance. It was a pleasure. And I guess I have to forget, not trying to plug myself, but I think you have to fill out judges' ballots as well, because I get scored. So go ahead and do that. Once you're done submitting that, everything should be done for today. Again, congrats, great job. And I want to thank the jurors too for, I know you may not be physically there, but to spend the time to watch these students. I know it means the world to them, and to give your experience feedback as a fellow coach, it's instrumental to the program and to the competition. So thank you, jurors. Thank you, advocates. Hope you have a great one, and good luck.